Hills or the attorney speak for this? The court isn't.
Nobody can say anything.
Yeah,
but you.
you can watch and observe, but afterwards we can questions or try to.
Thank you so much.
Yeah, you're welcome.
Our seats.
Good morning, everyone. The court just asked that I remind everyone to please turn off their cell phones and also to let everyone know that we do live stream all of the arguments and the microphones are on, so the World Wide Web can hear you. Thanks. This is just a reminder to anyone entering the courtroom, please make sure your cell phones are turned off. And also I'd like to inform you that we do live stream the arguments, so anything you say right before the argument can be heard from the internet, so thank you. Yes,
You live stream?
we do live stream.
I didn't know that. Can my clients,
What's that?
in Miami and New York, is it any way they could get on and listen to it?
Yes, if you go, Mariah, would you be able to help this woman?
It's on YouTube if you go to search Iowa Court of Appeals. Do you want me to?
Okay, yeah, I'll let you.
Yeah, I can step out here with you.
Okay.
All rise. Hear ye, hear ye, hear ye. I present to you the Honorable Presiding Judge Greer, Honorable Associate Judge Chatelli, and Honorable Senior Judge Danielson of the Iowa Court of Appeals. The Iowa Court of Appeals is now in session.
Please be seated.
We have two cases to hear this morning, and the first one is State versus Brown. Ms. Stewart, you're arguing for Mr. Brown, and Kyle Hansen for the state, and we're ready whenever you are.
May it please the court, counsel, my name is Ashley Stewart, and I represent the appellant Waylon Brown. When the district court forced Mr. Brown to choose between his right to a 12-person jury and a nine-day delay in proceedings, it violated his right to a fair trial. Additionally, there was insufficient evidence to convict Mr. Brown of first-degree murder and his first-degree robbery, and his first-degree robbery and willful injury convictions should merge. Brown was forced to make a tough choice in this case. He was forced to decide whether he should wait a week or more for jury deliberations to begin, or if he should waive his right to a 12-person jury and let 11 persons decide his case. The facts are as followed, and I'll go through these quickly. Beginning on the Thursday of his trial, a juror didn't show up. A juror was missing. And in an attempt to find the juror, it was discovered that he overslept. But by the time he arrived for court proceedings, the day was lost. and that was Thursday. So the first day of deliberations was lost. The court then asked jurors if they could come back Friday. 2 jurors said they had a conflict in their schedule, and so they couldn't come back. And so then Friday was lost. Of course, court doesn't convene on Saturday and Sunday, so that's 4 days. On Monday, jurors returned to find that another juror was ill. At the end of the day, at 4:30 or around 4 p.m., that juror confirmed that he had tested positive for COVID. So that's another day lost. That's day 5. And then per CDC guidelines, the court delayed proceedings for 5 more days for that juror to get over COVID and be able to not pass it on to other jurors. So that totaled a 9-day delay. Within that time frame, the defense constantly asked for a motion for mistrial, which was always denied. The basis of that motion was because jurors' memories were going to get less and less accurate as the days went on. They were going to be exposed to outside influences and things of that nature. And that's exactly why the mistrials should have been granted. A 9-day delay is unfair to Mr. Brown because when jurors go missing, they are exposed to outside influences, family influences, friends. They can also talk about the case, even though they might be told not to. And of course, memory becomes faulty. I will point out in this case, not much curative work was done by the court to make sure that the jurors wouldn't talk about the case or wouldn't lose their memory. And I should point out, this delay happened at the conclusion of all evidence. So there would be no time for the jury to come back and get their memories refreshed or hear more evidence from the defense. The only thing that was left to be heard was closing arguments, which, as you know, is not evidence. And so for those reasons, the trial shouldn't have been delayed. A mistrial should have been granted. I know the state talks about judicial fairness, judicial economy and why the mistrial shouldn't have been granted for those reasons. But I venture to say that judicial economy does not trump the Constitution, which guarantees a right to a fair trial. And in this case, Mr. Brown didn't get that.
You really don't have any evidence of the jury being improperly influenced during this stretch of time, do you?
That is true. But I will say that any time a juror's decision is undermined or something could have influenced it, we should err on the side of caution and grant a mistrial. Now, that also goes back to the judge not really digging and doing and asking questions as to whether the juror was influenced or by outside influences or whether their memory was tainted. In all the cases the state presented from the federal level, that did happen. The judges did do more curative things to make sure that the jury was still adequate. But not only that, the difference between this case and those cases as well is that there was no more evidence to be heard. In those cases, the delays happened after the prosecution presented their evidence. The defense still had a chance to come back and talk about what they needed to and even rebut some of the state's case. In this case, there was not that instance. They didn't get that chance again.
Had at least the ability to hear the summaries and closings of the evidence. And is there any reference or argument that the jury summaries, the closings were inaccurate or misstating what the jurors heard?
No, there's no evidence of that. But I will say, obviously, closing arguments are one side's version of what happened. It's not like when you hear witness testimony where one side gets to question first and direct, and then the other side gets to do cross-examination, and the jury can hear it as a whole. And the closing arguments are just what one side wants you to hear. And so that's why that would not have been enough. As far as the merger argument, as you know, Mr. Brown was convicted of robbery in the first and willful injury, and the argument here is that they should merge. And it's based on not just the statutory elements test. Brown is arguing that the elements of both cases, although in the statutory elements case, you put the cases together and you see that the elements match up, and then that should resolve it. But Brown is saying you should look further than just the statutory elements. That's just an aid. The impossibility test really says, could one not have happened without the other? Could the lesser not have happened without the greater? And in this case, that's exactly right. The robbery with the bat, with the dangerous weapon, happened, is the argument that happened, but the willful could not have happened without the robbery. They're the same facts, they're based on the same predicate, the same dangerous weapon. And so Brown argues that they should merge because of that. One could have happened without the other. It's not strictly based on an elements test. And as far as the sufficiency argument, for robbery in the first degree, Mr. Brown had to have knowledge of the baseball bat that was used against the victim. Here, there's no evidence that Mr. Brown had knowledge of the baseball bat. There's no evidence that he and Mr. White, the co-defendant, who was tried separately, even discussed having a bat. There's no indication that Mr. Brown made a plan to have a bat. Mr. Brown never in the video was seen with the bat, and the video is a short clip, but he was never seen with the bat. The victim never said that Mr. Brown struck him with the bat or any weapon. And so without knowledge of the dangerous weapon, yes.
To the video evidence, isn't the jury free to make the determination as to whether they thought that Brown must have known that White wielded the bat?
I think that's correct. I do, but I venture to say that the state still has to prove it through some evidence. I don't think that the video is enough, especially because the video doesn't show any evidence of Mr. Brown having knowledge of the bat. It just shows that Mr. White had the bat, but that is not enough to show that Mr. Brown knew that Mr. White had the bat. And knowledge, as you know, is essential in robbery in the first degree. And so without that knowledge, then robbery in the first degree, a conviction can't stand. Possibly robbery in the second degree could, but of course in our brief, we argue that Mr. Brown is not guilty of robbery in the second degree either. There's no evidence here that there was a plan to rob the victim. And Mr. Brown testifies himself that he wasn't involved in the robbery, that this was just a misunderstanding. Mr. White, the co-defendant, submitted an affidavit saying that Mr. Brown was not involved in the robbery and also didn't know anything about the bat. And I think that's enough to provide a reasonable doubt and that Mr. Brown is not guilty of second degree or first degree robbery. And so if there are no further questions, I'll wrap up. Thank you, Your Honors.
Whenever you're ready, we'll hear arguments for the state.
Good morning, may it please the court. Defendant Brown received a fair trial. It was reasonable for the court to delay trial for a few days to allow for the juror to recover from COVID-19 infection. Rule 219 sub 5 expressly grants the district court discretion to allow separation of the jurors during trial, and it includes up to the time of deliberations can allow the jury to separate temporarily for emergencies. This, of course, happened before deliberations started, so there were no limitations except for the court's sound discretion. If we look at what courts have done around the country, they've recognized that COVID-19 is an exceptional impact on the courts. It just interferes with how trials happen when people come together, witnesses, judges, jurors. If somebody has COVID-19, the court virtually has no chance or no option but to suspend the trial.
Your opposing counsel indicated that the court did not do enough to assure that there are no outside influences. Any response to that?
First of all, there's no evidence that there was any outside influence on the jury. It's not unusual for trials to last 9 days, so we never presume in a 9-day trial that somebody must have talked to the jurors inappropriately. But beyond that, the jurors were admonished. They received the standard admonition, advised them not to talk about the case with anyone, and importantly, on the second day of trial, January 20th, when they separated, the court on page 12 reminded them of the admonition. Finally, the defense had the opportunity to file a motion for new trial and subpoena jurors to ask them questions about whether any outside influences acted on them during that separation. and there was no such evidence presented. So courts around the country have found much longer delays appropriate than what happened here. Here it was 9 days. Courts in California found up to 103 days was reasonable. Granted, there are some courts that have found mistrials were appropriate, but the theme of those cases that I cited was that those courts had explored every other option but to grant a mistrial. It was a manifest necessity to grant a mistrial. And in particular, those courts had explored, could we have a short delay and bring the jury back to continue? And for whatever reason, whether it was unavailability of judges, of attorneys, of jurors themselves, it was not an option in those cases to bring back the jury after a short delay. So that is a difference from what happened here, where after a relatively short time, the jury was back together and continued their roles.
Counsel, can I turn you to the merger issue? The opposing counsel has cited in their brief State versus Velez regarding whether this was a case involving one unit of prosecution, one assault, which has been split between the two offenses. Can you respond or tell me if you think that applies in this case?
No, it does not apply. And the reason it doesn't apply is because when we're looking at legislative intent for multiple punishment, we look at the crimes as the legislature has defined them. So I believe it's the Anderson case I cited in my brief. We're looking at the elements that were actually marshaled to the jury. And in this case, I think it would be much different. It would be much more like Hickman if the jury had been marshaled on the purposely inflict serious injury alternative of first-degree robbery, but it wasn't. It was only instructed on the armed with a dangerous weapon alternative.
One assault, that being the bat by Mr. White. Does that make a difference?
Difference, no, because the court has consistently applied the legal elements test, and each one of these offenses contained an element that was not included in the other offense. So first-degree robbery requires intent to commit a theft, and it required to be armed with a dangerous weapon, which are not elements of willful injury. Willful injury required intent to inflict serious injury and a resulting serious injury, which were not elements of first-degree robbery as they were marshaled to the jury. So we should not dive down into the facts. There are plenty of instances where a defendant's conduct is going to violate multiple statutes, and if the legislature has defined different crimes based on overlapping facts, that is the legislature's prerogative, and the person can be punished for both offenses. Finally, with the sufficiency of the evidence, it really was not a hard case. The victim testified that Mr. Brown yelled at his accomplice to get him, that Mr. Brown chased along after the victim, and that Mr. Brown, in fact, told his co-defendant to take the victim's backpack. That satisfies the elements of first-degree robbery. He also knew that his co-defendant was armed with a dangerous weapon. A baseball bat is not like a gun that can be concealed easily on somebody's person. And in fact, in this one, they are running shoulder to shoulder after the victim with the co-defendant raising the baseball bat. And in fact, during the attack, it's clear that the co-defendant holding the baseball bat was in front of Defendant Brown. Otherwise, Defendant Brown would have been the one who got whacked in the back of the head with a bat. Additionally, the jury had the videotape. It's not perfect, but it does show more than enough for a reasonable jury to find that he was an active participant in this robbery. There's a point where after the co-defendant swings the bat, you can see the defendant himself raise up and kick toward where the victim is lying on the ground. And you also see defendant himself bend down toward where the victim is and pick something up and put it in his pocket. So that matches the victim's testimony, and it does not crucially match the defendant's various stories, where at one point he's unknowingly helping Mr. White, another time he's trying to push Mr. White off, and then finally Mr. White's affidavit where he says Mr. Brown didn't have any role. The videotape just simply does not match that, and the jury had no reason to believe the story that the defense was presenting. The videotape is another good reason that there was no prejudice for the temporary separation, because the jury could watch that videotape and be refreshed about what happened. The jury was allowed to take notes. The jury got to hear closing arguments right before they began deliberations. All of those factors indicate that its memory was not irreparably harmed by the temporary separation. So for those reasons, the state asks that this court affirm Defendant Brown's convictions for first-degree robbery and willful injury. Thank you.
Mr. Hanson, rebuttal. Ms. Stewart?
Thank you. I'll start with the jury separation. That's where we left off and began the whole thing, so I'll start there. Even though COVID has had an exceptional impact on the courts, we must remember that COVID doesn't trump the Constitution. And so every defendant is still granted or given a right to a fair trial. I think in this case, the state did point out that the judge gave an admonition, but they were the normal admonitions, and it was only before the jury separated. When the jury came back, there was no inquiry as to what happened in that 9-day delay. I would say in the federal cases, there was that inquiry. In the federal cases at the state sites, the courts have repeatedly asked the jurors about their memory, what was happening, if they had any outside influences. None of that happened here.
Just center on the video. And so would you address counsel's assertion that the jury had the benefit then of reviewing the video?
There's no indication that the jury watched the video again. And so since there's no indication, although they might have had access to it, we can't say that that refreshed their recollection if we don't know that they actually watched the video. And beyond that, it's more than just memory loss. Memory loss is an important thing, but I think I also cited in the brief, there's outside influences. There's a lot of things happening here. The jury was told that I believe that this would be a 3-day trial. It stretched into being 12 days. And we cite that maybe, or we argue that maybe that also influenced them in being in a hurry to leave and render this verdict. There are a lot of things that could have impacted the jury, and we don't know what they were, but we also don't know that their memories were refreshed in between that 9-day period. And I also want to highlight, I said it before and I'll say it again, in the federal cases where these have happened, most of the delays have been in between the prosecutor's case in chief and the defense's case in chief. That's something important to highlight, because that means that the jury was able to come back and hear more evidence, not just a closing argument, not just be dependent on possible notes that they took. We don't even know how thorough the jurors' notes were. And so for those reasons, there was no fair trial here. The delay impacted Mr. Brown severely. And as far as the merger that Judge Danielson talked about, I think that you have to go beyond the elements test. And then if you go beyond the elements test, then you see that, that the two crimes are the same and should merge. You needed to have the bat in the robbery to even get to the willful. It's one act. There's not multiple. The jury wasn't advised to find multiple acts. And so because there's one act, it should merge. And I think that because it should merge, the willful should be dismissed. And then as far as robbery in the first degree, once again, there's no knowledge that was presented here. Knowledge is important for robbery in the first degree. Mr. Brown has to know that a dangerous weapon is going to be used. And there was no evidence that Mr. Brown knew that. At most, maybe there's evidence of a second-degree robbery, which is what you're in the purview to find if you dismiss the first degree. But of course, we argue that there's no chance of a second degree either. But there's absolutely no proof of a first-degree robbery. And so if there are no further questions, for those reasons, we ask that you vacate Mr. Brown's conviction. Thank you.
And counsel, thank you for your good briefing and excellent arguments here today. We appreciate that. We will consider State of Iowa versus Brown, case 220324 submitted. Thank you. We'll get our ruling out as soon as we can. Our next case this morning will be State versus Vogel. So we'll let counsel set up. And that's case 21-1931. And I believe we have Mr. Irwin arguing for Mr. Vogel and Mr. Bennett arguing for the state. Anytime you're ready, please proceed.
Thank you, Your Honor. May it please the court, counsel. The state was required at trial to prove every element of the offenses of conviction beyond a reasonable doubt, and it failed to do so. First, because the evidence was insufficient to lead a rational juror to conclude the elements of premeditation, deliberation, and malice aforethought were proved beyond a reasonable doubt, Vogel's conviction for murder in the first degree should be vacated and the case remanded for entry of conviction of an appropriate lesser included offense, if any applies. We suggest in our briefing that that appropriate lesser included offense is involuntary manslaughter. Additionally, because the evidence was insufficient to establish that he directly participated in any of the requirements for a conviction for abuse of a corpse, and there is no lesser included offense for that conviction, that conviction should be vacated and the case remanded for dismissal of that count. Beginning with the elements of premeditation and deliberation, which are necessary for first-degree murder. Pursuant to the Buenaventura case, those elements may be shown through planning activity by the defendant, motive based on the relationship between the defendant and the victim, or the nature of the killing, including the use of a deadly weapon combined with opportunity to deliberate. There was insufficient evidence to establish any of those alternatives here.
Although the rope is not identified specifically as a dangerous weapon in the statute, an object that's used to indicate an intent to inflict death or serious injury is defined as a dangerous weapon. Do you agree?
I agree, Your Honor.
Why couldn't the jury then consider the rope a dangerous weapon under that jury instruction?
Because, Your Honor, the evidence was insufficient to establish beyond a reasonable doubt that a rope was involved here. To be sure, that was certainly the state's theory, and there was some evidence presented that that could be a possibility. Dr. Catalier testified that the wounds to Mr. Williams' neck could be consistent, did perhaps look like a ligature furrow, but she also was open about the fact that the injuries caused internally to Mr. Williams' neck were also consistent with manual strangulation. And so that, I think, undermines a conclusion beyond a reasonable doubt that the rope was involved.
Mr. Vogel also admitted to Haynes, did he not, that he in fact used the rope?
Yes, that statement was entered into evidence through Mr. Haynes. That is correct. But I think that needs to be considered in light of the other evidence or lack thereof which does not support such a conclusion. Specifically, that two different investigators examined the scene for any indication in the rafters, any marks, anything like that, that actually occurred, and neither found anything. There's also the issue with Mr. Haynes' testimony, and I do acknowledge that credibility is for the jury, but it was entered into evidence that there were there was lots of speculation and rumors about what happened taking place on social media and on the internet. And I believe Mr. Haynes acknowledged he had been exposed to that information. And I think that should still be taken into account, whether that affected his recollection of what he purported Mr. Vogel told him. And again, particularly in light of the lack of any physical evidence when investigators looked for something to corroborate that purported statement by Mr. Vogel. There was also lack of any evidence of planning activity here. The first option under Buenaventura, as outlined in our brief, it's unclear how Williams came to be in Mr. Vogel's home that day. There was no evidence presented. There was speculative assertions during opening statements and closing arguments about that, but no evidence actually backed up those assertions by the prosecutor. So we simply don't know how Mr. Williams came to be there. There was nothing indicating that there was a plan, and particularly viewed also in light of the aftermath with Mr. Vogel frantically trying to figure out what to do next. Those issues would have been readily apparent had someone planned this. And so I think that also weighs against a conclusion that there was any planning activity. Somewhat related, there was also no evidence about the nature of their relationship. In fact, nothing established they even knew each other before this happened. The state pointed to portions of the transcript that indicated that the witnesses and Mr. Williams and Mr. Vogel were all drug users, but none of those portions of the transcript actually say that Vogel and Williams had ever met one another. It was Haynes testifying that he had used drugs with Mr. Williams and things of that nature. And additionally, one of the main places it seems that was presented where people got together to use was at the witness Johnson's house. Johnson testified he did not know Mr. Williams, and so that also weighs against any finding that they even knew each other.
Specific details that Williams got in an argument with Vogel over this girl situation in the rehab, and those are pretty specific details that apparently Mr. Vogel told Mr. Haynes, right?
There were, I would disagree a little that they were particularly specific, but yes, there was discussion. I believe both witnesses, Johnson and Haynes, purported that Vogel told them there was some sort of argument over a girlfriend or an ex-girlfriend, but we still don't know when Vogel came to, assuming he had some belief that Williams was interfering with that relationship, we don't know when he came to believe that. If it happened during any discussion that happened that day, which would still weigh against any sort of plan beforehand, or even whether that was something that he considered relevant after the fact. We just simply don't know when Mr. Vogel came to believe that and what influence it had on him. We've discussed the deadly weapon option under Buenaventura a bit. I would also emphasize there, as well as no ligature being identified, there was also no blunt weapon identified. The state's theory was that it was one of two bats collected from the home, but there was no DNA on either of those bats. There was also lack of any skull fracture, hemorrhaging, there were lacerations to Mr. Williams' skin, but beyond that, there just weren't the kind of serious injuries one would expect to see from someone being struck with a bat. And even if there were sufficient evidence of a dangerous weapon being involved, there is still insufficient evidence of an opportunity to deliberate, and that was required under jury instruction 19. That deliberation has to occur prior to the act that results in death, and there was no evidence that would support that there was such deliberation here.
Was used, obviously, Mr. Vogel would have had to take time to think about grabbing a rope, putting the rope around the victim's neck, throwing the rope, if we abide by the state's claim, rope over the rafter, and pulling the rope tight for as long as 6 minutes. Isn't there enough showing there for deliberation?
I don't believe there is, Your Honor. First, the sort of predicate acts that you refer to prior to the actual purported act of pulling the rope, the evidence seemed to indicate that there was some sort of argument and maybe even a fight going on when that took place. I think that weighs against a conclusion that Vogel had the opportunity really to think about what he was doing. I recognize that it doesn't need to take place for any particular amount of time, but it still does need to take place prior to the act. And that also is why I think it would be inappropriate to consider the amount of time that potentially it takes to strangle someone, because that's during the act. That is not prior to the act that resulted in death. And so while perhaps I know there was testimony about how long that could take, it still doesn't establish premeditation or deliberation prior to the act, and that's the most important part. I'll move a little quickly. I'm almost out of time. I know I get rebuttal. But for many of the same reasons I've discussed, the evidence was also insufficient to establish malice aforethought. That also had to exist prior to the act resulting in death. And for the reasons I've outlined, I don't think a reasonable jury could conclude beyond a reasonable doubt that that took place. I see my time is almost up, so I'll return on rebuttal. Thank you.
Mr. Bennett, would you please make your arguments for the state?
May it please the court. I think the evidence here, even though there's not extensive evidence of planning beforehand or development of a prior relationship between Mr. Williams and the defendant, or a lot of testimony regarding the motive, we still have enough here to show the elements that are being contested: premeditation, willfulness, deliberation, intent to kill, malice aforethought. We submit that evidence was sufficient here. First, as the court knows, there's no minimum amount of time needed to establish premeditation or deliberation. We can basically look at the acts themselves to make a determination. Oftentimes, State versus Blair, we cite in our brief, where the victim was stabbed to death 4 times. There was evidence of motive there. They wanted to take his car, but also the court noted that the time taken to bind his hands and feet was sufficient time and opportunity to deliberate and premeditate what they were doing. And in the Wilkins case, we cite in our brief, is where there was a bar fight, and then the defendant pulled out a gun and shot the victim several times, killing him in front of a number of witnesses. And the court said, because before he shouted out the victim's name. That was enough time to think about what he was doing, enough to show premeditation and deliberation. In that case, there was nothing else really developed regarding motive or anything else. We have that here. We have enough time. I disagree with the argument that, well, you can't consider the act as part of the premeditation deliberation. It takes time to kill somebody by strangulation. The doctor testified at a minimum, I guess, 6 minutes or more than 6 minutes if the pressure is consistent before one can strangle somebody to death. And I think because while you're doing that, you have time to think about what you're doing, to deliberate, because you can stop at any point if you decide you don't want to actually kill the individual. So we submit that, and we cite some out-of-state cases, but I think for a reasonable proposition that in the case of strangulation, you really don't need much more for premeditation deliberation. Well, we have more here. We have evidence of the motive. So I think that we have enough to show those elements and that the jury's conviction should be affirmed. We have evidence primarily from Nathaniel Haynes that the defendant, now he's admitted his guilt and shows the body of Mr. Williams to Haynes, and he does it with Cody Johnson, and he admits his guilt to his sister later on too. So he's admitted his guilt more than once. Haynes talks about the fact that the defendant told him that an altercation occurred because the defendant believed that Mr. Williams had somehow interfered with his girlfriend's drug rehabilitation, and the defendant, apparently from what was developed, had arranged for her to go into drug rehab. She was a drug user too. We submit that is the motive here. That's enough evidence to show motive, but the nature of the death by strangulation, in this case, we submit provides anything you need more for that to uphold the jury's verdict, that all the elements, malice aforethought, it's all bound up with that. And we submit.
Link Mr. Vogel to the abuse of the corpse.
Well, as we know, contrary to earlier times, circumstantial evidence is as probative as direct evidence. We do not have any direct evidence that the defendant was involved, but we submit the circumstantial evidence here and reasonable inferences drawn from it by the fact finder is sufficient. Defendant lives, and the murder is committed in the Grinnell home where defendant lives with his mother and along with her boyfriend, Roy Garner. Now, we have evidence that we believe it was September 12th, that probably, or early September 13th, when the murder occurred, based on his last contact with his cousin. And around the 13th, the two people, Cody Johnson and Haynes, are not sure, but they each independently are brought to the defendant's home, to the basement. He admits that he killed Michael Williams, shows them his body, and tries to solicit their help in him getting the body out of the basement. Now, Mr. Johnson, at one point after the day he is brought over there and sees the body, he does help him move the body from one location to another in the basement. But after that, after those days that they came over, there were the testimony that defendant came back and to each one and said, "We need to do something about this." Obviously, talking about getting the body out of there. So he's trying to enlist. He's trying to get people to help him. Now, on the 16th of September, and later, late afternoon, early evening, is when the body of Mr. Williams is discovered to be burning along a ditch in a rural part of the county. But prior to that, there's a woman, Jolene Brady, who is driving along that road, and she sees two pickups. Two people are in each pickup. One pickup truck has some personal items in the back, a bicycle, I think she said there was a mattress, and some totes that presumably were carrying personality, some property, and a tarp covering something under which she could not see what was being covered. There were two people in that pickup, but as she said, they were wearing COVID masks and she could not identify them. She believed they were both males, but she also saw a second pickup. Two people also were inside that pickup, but the driver was not masked, and she later identified Roy Garner as the driver of that pickup, and I believe the evidence shows that the truck was later identified by her. So there's two pickups here. One has some personal property and something else is being hidden by a tarp. But Roy Garner's pickup there and Roy Garner there. And later that day, Roy Garner's pickup shows up in Marshalltown, about 30 minutes away from Grinnell, I believe. After the defendant's mother called the sister and said, "The defendant wants to stay with you for a while. We're coming over." And the pickup shows up, Roy Garner's pickup. The mom is in there. The defendant is in there. And what's in the back? A bicycle and some totes. And then he persuades the sister, I believe, that he could stay there for a while. So defendant's tied because Roy Garner lives in the home where he lives and where the murder occurred, tied to Roy Garner. Roy Garner and his pickup is tied to the scene that it was short in time before the fire started. And he is put with Roy Garner and the pickup in the same property that is seen at that scene where the fire later occurs, and defendant's with the pickup and that property now. We submit it's a reasonable inference that one of those four people was the defendant in this case, and that he gets in that pickup in Grinnell, and he ends up in a pickup linked to the middle part where we see the two pickups And he ends up in Marshalltown with that property that was observed, and we think it's just one continuing thing, and he was one of those individuals. Under the old standard, yeah, the state might be hard-pressed, but we know the circumstantial evidence is equally probative, sometimes even better than direct evidence, not subject to challenge regarding, you know, ability to perceive and bias and interest like that. We submit this evidence is enough. It's about what the jury the evidence taken in the light most favorable to the state, deferring to the fact finder. It's whether there was enough for this jury to make the decision it did, and enough to where there's no place for this court to become involved. We submit there was enough evidence to uphold the abuse of corpse conviction, as we also believe that the first-degree murder conviction should be upheld. None of the lessers apply here. Maybe in some situations, but this is not a case of reckless strangulation. This was an intentional murder of Michael Williams, and the first-degree murder conviction and life sentence was appropriate. Thank you.
Rebuttal?
So I'd like to pick up with the abuse of a corpse conviction because I didn't have any time to discuss that my first go-around. These things it is true that circumstantial evidence can support a conviction, but that evidence must give rise to more than speculation, suspicion, or conjecture. And I submit that's exactly what the state is describing here, solely based on the fact that there were 4 people in 2 trucks, and that one of those people was Mr. Vogel's stepfather. The state suggests that this jury could conclude without speculation, suspicion, or conjecture, but beyond a reasonable doubt, that Mr. Vogel directly participated in those acts. Your Honor.
The defendant had the body and wrapped it up and then recruited people to help him move it. Is that all correct?
There was evidence to that effect, yes.
And the defendant had no vehicle, correct?
I believe that was testified to, yes.
Somebody to help him with a pickup if he's going to move the body, correct?
I would agree, yes.
So, as your opposing counsels indicated, is there a reason why the jury could not infer that the person that had the body, that wanted to move the body, did in fact find somebody with a vehicle and did move the body, and it just so happened that the defendant lived with Mr. Garner and shows up in Marshalltown with Mr. Garner the same afternoon? Is that not enough for the jury to convict on this offense?
Your Honor, I still submit that that only adds up to speculation or suspicion. Certainly, I could see suspicion from those events, but I don't think it adds up to a conclusion beyond a reasonable doubt that Mr. Vogel directly participated in this act. I think that's important. The state did not pursue this under an aiding and abetting theory, under the theory that he encouraged other people to do this. They charged him as a principal, and that means they had to prove beyond a reasonable doubt that he directly participated in the mutilation, disfigurement, or dismemberment of Mr. Williams. And I submit the evidence was insufficient to reach that conclusion. I would also point out, opposing counsel talked a bit about the timeline. That timeline also supports a conclusion that Mr. Vogel was not there. The testimony was that Vogel, Garner, and Ms. Cox arrived at Vogel's sister's house at 4:00 p.m. The witness who saw the 2 trucks driving by, she estimated between 4:15 and 4:30. Vogel's sister never testified that Vogel left. I will grant she also never testified that Mr. Garner left, but his whereabouts are definitively accounted for. The witness identified him there. But as to Mr. Vogel, all we have is that he is at his sister's house at between 4:00 and 4:15, no testimony that he left, and no direct evidence that he was in either of those trucks.
Showed up in the same pickup in Marshalltown.
That's correct, Your Honor. But on this timeline, at least, prior to that pickup being seen in the ditch by 15 minutes to a half an hour. And so, yes, I agree that that pickup was Mr. Vogel's stepfather's pickup. He appears to have ridden in it out to his sister's house, but that's where the evidence ends. We don't know what happened with Mr. Vogel after that. He is unaccounted for, and so I think that weighs against a finding that he directly participated in these acts. And then also the lack of any DNA evidence of Vogel's anywhere, frankly. At the scene of the ditch in Mr. Garner's truck, there was just nothing tying him to direct participation in these acts. And then just returning very briefly to the first-degree murder conviction, I know the state believes that the time spent during the act of strangulation should be taken into consideration. I disagree. The jury was instructed that these state-of-mind elements had to have occurred prior to the act. If the state wanted an instruction that said that they can occur during the act, they could have requested that instruction. They did not. The jury instructions control this case, and they say that Vogel had to have those states of mind prior to the act which resulted in death. And I submit that the evidence was insufficient to establish that was the case. Thank you.
Counsel, thank you for the excellent briefing and arguments here today. We will consider State versus Vogel submitted and get our ruling out as soon as we can. Thank you.
All rise.
No, so they publish them, they come out on the website every couple of weeks. And so it's hard to say, it depends how long they take to come to a conclusion together and edit that and get it out. So it's on Wednesdays typically, but they publish cases, and so it could be.
How we doing? Good, you? Quite a full house that last case.
Yeah, we're still kind of lingering. I'm on a kind of a touchy deal. A lot of emotions.
Oh, I'm sure. It's always nice to sit up here sometimes because you can see like reactions. You know?
Yeah. And you would hope by now, because they all sat through the trial and everything else, that they've already heard the worst of the worst, so this is just legal arguments.
Oh yeah, like this is more like like case names and
Yeah.
you don't actually see anything. You don't have to. Yeah, I'm sure it's a little less traumatic, but even then, it still brings up something that like this case was from I think early 2021. So
Mhm.
you know, it's
Well, everybody wants to move on and you never forget, but you want to
oh yeah.
heal and
Until
this just keeps picking the wound.
until that final ruling comes out, it's never not over. Yeah,
Yeah.
like this could be of course appealed again upstairs. So
Uh-huh.
yeah, I can see that balance between
I'm here.
hoping something could change, but also like it isn't over until it's over.
Yeah, I remember this. See, in my opinion, the state guy, instead of coming out here and having his phone, get him downstairs and have that conversation downstairs with him.
Oh, did he say something to the?
No, I'm just saying the state. He's out there just chatting with the whole family.
Oh, the state's talking to the family right now?
Well, the family is of the deceased.
Oh, okay,
Well,
I understand now.
They have on the back of a couple of the shirts it says "Justice for Williams,"
Got it.
and I think he was the deceased, right?
I don't know this, my judgment on the case.
I think Williams was the one that was murdered.
Okay.
So,
Yeah, no, I assumed they were here for like that is much worse. Or not much worse, but you know what I mean? Yeah, like
Yeah.
that's like their loved one, yeah.
yeah. So, on our perspective, we just shouldn't
Oh, yeah.
get down the first floor so no one gets tossed over the frickin' railing or something.
It's safe, the less people in this building, I imagine makes your job much easier, right?
Yes.
I always get nervous coming out when there's court in session. I'm like, oh my gosh. This is, oh yeah, because he's going to be here for this afternoon too.
I know, so I put this
Oh,
here for him.
gosh. What the heck?
Should I leave it here?
Yes.
Okay. And I sent it to him when I was in Hawaii, and I said, hey, your ad campaign's working.
What do you think that was for? Just like somebody did that?
Who would have that?
I don't, exactly.
I mean, what a weirdo.
this right before, just click it back.
Tabor, Schumacher, and Tabor, Schumacher, and Allers. Schumacher, Tabor, and Allers.
Seifert, right?
Yeah.
Good German name.
Yeah, my,
Probably you get some
Here, I'll tell you.
it's all mixed up beside back to my grandma's.
There are lots of
Very obviously Irish, with the last name Hickey and red hair. That's my mom's side is English, so.
a lot of secrets over in Eastern Europe.
So my dad is from both sides. That's where I grew up. Maybe COVID, maybe post-COVID, people. I like this table says people for Apple phones as people come in here, we want to get as close as possible. So
I don't want to see the action.
They read the old ones.
New one.
Judge, it wasn't so now, Judge Joy years ago. He said, look, Judge, this is in common. Said before, we want you to read this one. Of course, you actually, it goes into the jury, we're all out of the way. County, and they're still in Marion County.
Marion County, is that still in Iowa? Is that still in Iowa?
Yeah.
Or is that Missouri now?
Yeah, that's one more tear down. And then, it was legal action. Awesome. And they go, so then the AG side, me Stevens and I both agree. He's kind of like this whole, this is sex abuse case that was kind of shaky to start with. Never just kind of reach out and say, hey, he learned his lesson, let's not retry it. We had a 2-hour window on the party. And Dad was running the camera. He was accused of molesting to a girl. Then we all photographs. We put together in 2 hours. There was like 15 minutes that he wasn't coming. Oh. I mean, literally in the 2 hours. And then she was told not to come in this room. I had to tell her. She says, yeah, we're playing hide and seek. I said, well, it's fine. She said, no, I said, so you mostly hide, but nobody was sitting. And then she said, how long are you in there? She said, forever. So she didn't have a spatial relation. It was crazy. That one charge had been changed for like 3 years at the time that we done it. And he read the old. So everything else good? Yes. Good. You're looking like this life's treating you spectacular. Always.
everyone. The court would like me to remind you, please turn off your cell phones before the argument. And also, I need to inform you that we do live stream the arguments. So anything you say can be picked up by the microphones and displayed over the internet. So please keep that in consideration. Thanks. presiding Judge Tabor and Associate Judges Schumacher and Allers of the Iowa Court of Appeals. The Iowa Court of Appeals is now in session.
You may be seated. Good morning. Welcome to the Iowa Court of Appeals. We're set to hear 4 arguments in the second morning session. There'll be a panel change between the first and second arguments, and so we won't adjourn. We'll just change the personnel here. But the first argument that we're set to hear is in State versus Church. We have Mr. Leon Spies for the appellant defendant and Mr. Nicholas Seifert for the state appellee. Mr. Spies, when you're ready.
Good morning, and may it please the court, Mr. Seifert. I'm pleased to be here this morning to speak on behalf of Johnny Blahnik Church, who is appealing his conviction and sentence following his conviction in Lynn County District Court for murder in the second degree, having been prosecuted for murder in the first degree, and for his conviction for abuse of a corpse and obstruction of a prosecution. This is a single issue case involving the district court's decision to administer an Allen charge, the so-called dynamite charge, following news from the jury that the jury was deadlocked. This is a case in which the district court not only knew that the jury was deadlocked, but that the jurors had singled out a single holdout juror who they believe was failing to follow the instructions, was failing to participate.
Throughout your brief, it seems that the assumption was that this was an 11-1 split in favor of the state, right? So there was one holdout for acquittal, or whatever the holdout was for. But we don't really know that from the record, do we? I mean, it is possible that we have like a reverse 12 angry men situation here where you've got one holdout for conviction and 11 for acquittal. And then after the Allen charge or dynamite charge, 11 swayed. I realize it's probably more likely, given the final outcome, that only one switched instead of 11, but possibility exists for 11 switching, does it not?
Yeah, I would acknowledge it's a possibility, Judge Alders, but I think that the triangulation demonstrates that that's not what the case was. The jurors early on, I think on the second day of deliberation, told the judge that they were having problems with 2 jury instructions, and the 2 jury instructions dealt with self-defense, justification. That was the fighting issue in this trial every step of the way. I mean, Mr. Blahnik, at that time, now Johnny Church, acknowledged that he had stabbed Chris Bagley in the neck and killed him. So there was no dispute about that there was a killing here. The issue was whether or not it was in self-defense or defense of another. So from day one, that was the fighting issue. So then when the jury told the judge, look, we're having trouble with 2 jury instructions, and one juror is refusing to follow the instructions, that was the instructions on justification and self-defense. So to me, and I think everybody in the courtroom realized that the issue was whether or not there was a holdout for acquittal or for a lesser offense. So I grant you that theoretically it could be that there were 11 for acquittal and 1 for conviction, and that's what the split was. But I think that the clear import of the messages that they were getting was that it was 1 holding out for acquittal.
Can I ask you about the judge's knowledge of the split? In Piper, there seems to be an indication that as long as the judge doesn't ask for the breakdown, that it's not as not an abuse of discretion, or at least adds a factor to that test. Are we bound by that, or is it significant here, the judge's knowledge?
That there's a clear distinction about that, and I understand what the issue is in the Piper case. If the holdout juror knows that the judge knows who that juror is, and the jury knows who that holdout juror is, that there's going to be pressure on that particular juror because of who knows what about whom. But here we have a situation where the holdout juror knew that he or she was the holdout juror. The foreperson told the judge that we have 1 single juror who's not playing by the rules. And so the fact that the judge didn't know who that juror was in this situation doesn't make a difference. And the additional reason for that, Judge Tabor, is this, that by the middle of the 3rd day of deliberations, not only had the court been informed that there was an 11-1 split of some description, but now we have the jurors revolting and saying, we're not only voting 11-1, but we're voting 11-1 against this juror. We want this juror out of here because the juror is not playing by the rules. So there couldn't be any greater amount of pressure placed on that one holdout.
Related to that, I know in your reply brief, you had commented on the fact that in trying to distinguish Piper here, and your quote from the brief is, or the quote from your brief is, here both the trial judge and the jury itself knew that the issue was concentrated on a lone holdout. Wouldn't that have been the case in the 10-2 split in Piper as well? I mean, presumably everybody in the jury room knew who the two were that were holding out, if you will. And so how is that different from the situation in Piper where they said it was okay?
Yeah, that's a good question, Judge Allers, and here's where I think that the distinction is important. Not only would you have one holdout juror, not two, so you don't have an ally that's reinforcing your holdout. We have one holdout juror who's been fingered by the other jurors as not playing by the rules. The court knows it, the foreperson knows it, the jurors know it, the holdout knows it. And so we have a situation here where, as I pointed out from the sociologic research, when you have a holdout juror, the pressure on that person is enormous, because not only is it the fact that you're isolated, but that isolation leads to pressure from the other jurors, to criticism, to ridicule, to punishment. And the sociologic research shows that in situations like that, deliberations stop. There is no deliberations. Everybody is entrenched in their position. And so the purpose of an Allen charge, as we all know, having been judges in courtrooms before, is to institute a new train of deliberations. Well, this train was off the track a long time ago, and there was no way they were going to get back on track.
So I think you might have been looking at my notes ahead of time, Mr. Spies, because you keep naturally springboarding me to my next question I had for you. You seem to place great weight on the fact that this was an 11-1 split, and obviously the coercive nature, because everybody knows who the holdout is, the enormous pressure on this one juror. So are you essentially asking for a rule that says if it's an 11, if you know there's one holdout, you can't give an Allen charge because the pressure is always going to be enormous on that single juror? And if that is the case, what about 10-2? What about 9-3? What about, where do we split that baby?
Yeah. And the answer to your question, Judge Allers, is no, I'm not asking you to say that we should have a rule that when you have an 11-1 split, that an Allen charge is per se inappropriate. But what I'm saying is that under the unique situation in this case, given the hostility in that jury room that's being conveyed by the foreperson to the court.
And you get that hostility tag mainly from when they said that they voted 11-1. They decided to take a vote to decide whether the holdout was intentionally refusing to follow the instructions, and that came out 11-1 as well, not surprisingly. Yeah, okay.
In all the other cases that you've looked at, be it Piper or Davis or Campbell, it's not like, we've got a juror here who's refusing to participate. There was a split, they knew the split, or they didn't know the split, and an Allen charge was given. Well, here, we've got an indication that's different from all those cases, where you've got the jury in a revolt against one juror, and the pressure on that person is enormous. The other thing that's unique about this case, Judge Allers, is that we have a very experienced district court judge here who not once but twice said, I don't think this is appropriate to give an Allen charge. And
of course, didn't have the benefit of Davis, the Iowa Supreme Court's recent case on it. And if the judge had, would it be more likely that we'd find an abuse of discretion because the court really didn't follow that best practice that they lay out in Davis to refer the jury back to, I think it was instruction 15 here?
Yeah, I don't think the Davis case would have made a difference to the court in this situation, because Davis didn't do much more than say, this is the Campbell holding, this is the way we would prefer that the jury be instructed on their duty to re-examine their position and so forth. So I don't think that the Davis Supreme Court case would have made a difference to the court in this situation. And the other thing about...
Have you touched briefly on your remaining minute here? You mentioned the unique circumstances that were required to review of each case. How much weight do you think should we give to the fact that on the Thursday of the deliberations, the instructions from the court came all within about a 2-hour period, 10:06, 11:15, and then the final Allen charge at 12:08. Does that take this case outside the realm of the other cases that found it was appropriate?
I do in the sense that, as I mentioned to Judge Allers, the district court judge had some real reservations about giving an Allen charge of any description. First said, you know, if I do it, I think I'm going to wreck this guy's chance of a constitutionally fair trial. And then even the second time around, when he made the decision to give the Allen charge, he said, you know, I'm going to do it. I've got reservations about it. And if the Court of Appeals disagrees with me, they're going to deal with it that way. So the rapidity with which the verdict came in, I think, is insignificant in this situation because the jury had been deliberating for more than 2 days. And we knew that certainly by the beginning of the third day that the jurors were entrenched in their positions. The juror was quoted as saying, I'm not going to change my mind and I never will. The load was locked. The train was not going to get back on the track.
Thank you, Mr. Spies.
Thank you, Your Honors, counsel. No one is disputing here that the content of the Allen charge itself was permissible. Multiple appellate courts in this state have already said that that precise content is okay. And I think, Judge Allers, your questions have narrowed in on what I think is the key point, which is this case is effectively decided by Piper, the remaining issue. I think an 11-1 split is not functionally different than a 10-2 split.
Mr. Spies' suggestion that, you know, having at least one ally in the room makes the pressure different than when you've got no ally in the room. And not only no ally, but as he commented on, I think it is borne out by the notes, there's like some open hostility towards this one juror.
Sure. And so I would counter in a couple ways. First, I would say, you know, as you, I think, rightly identified in a couple of your questions, I don't think this case was meaningfully different than other cases where a jury deliberates for 2, 3, 4 days and has a holdout or a couple holdouts. I don't think we can rightly infer a greater degree of hostility here than in any other case where the majority thinks the minority is holding up the show.
Have to infer the hostility, do we? I mean, isn't it sort of playing on the four-persons note?
I wouldn't say you can infer more hostility. I'm not saying that there wasn't some degree of tension there. I will readily concede that the 11 are writing notes saying we have one person not following the rules. I don't know that that's distinguishable fairly from other cases where you have a split because I think there's an inherent conflict in all those cases, which is what the Allen charge is partially meant to address. The other...
Davis, one of the factors the Supreme Court recognizes, and this is when they were speaking of it, it went more to the content of the instruction, but they talked about what makes it coercive is it's really aimed at the minority jurors. And didn't that happen here through the four-persons notes, that it was really aimed at that person who they said, like, they don't even care that they're not following the instructions?
Well, and again, I guess to follow up, because I think the other point I was going to make kind of plays into this. Part of the problem with what the defendant is trying to do here, I think, again, Judge Allers, as you rightly pointed out, even if he's not saying it explicitly, I think is asking for somewhat of a carve-out rule that is different from the normal analysis for an 11-1 split. The problem there is, in this case, the court didn't ask about the split. The jury volunteered that up. To me, reading the case is the importance of the court asking about the split is it amplifies the inherent coerciveness of whatever comes next because the jurors feel like, okay, the judge is upset. They're asking, how many people am I really dealing with? And then when they give a subsequent instruction, an Allen charge, the feeling is, oh, well, they already asked and found out it was me specifically. Now they're talking to me. And so I think in the Piper case...
Different than the judge having that information. I mean, if we're looking at it from the perspective of the potentially coerced juror, a reasonable juror in that position, does it matter to that person whether it was volunteered by the foreperson or asked for it?
Well, I'm not sure. I guess my best way to answer that, Judge, is to say that, ironically enough, in one of the federal cases that opposing counsel cited in their brief, United States v. Burgos, If you track the quoted language of that back to the case it's quoting, that court actually says essentially that the judge knew of this split is not important because from the view of the juror, they always know that they're the holdout. You know, the impact or the coerciveness on that person is always going to be there. And we have Iowa appellate courts saying, we think it is a factor of coerciveness that the court might need to address if the court seeks to kind of suss out who that person is. But again, in Piper, you have almost an identical scenario. The jury submits a note saying we're split 10-2. There it even goes further and says 10 guilty, 2 not guilty, although it quickly amended that to say the 2 were more like not sure. And so I think regardless of if the judge knows of the split or not, if you're looking at the coerciveness to the juror, I'm not sure it's meaningful if the judge knows, because if I know I'm the one holdout, to the extent that anything is inherently coercive, I'm always going to feel that I'm the one being talked to. The trick here is that the judge intentionally used precise language that had been affirmed previously in multiple appellate cases and sent it back not even as a supplemental instruction, but in a note returned in response to a juror note to try and minimize the impact.
Best practice outlined in Davis. From here forward, if the court did what the court did here, it would be an abuse of discretion, right? Because it would be not following Davis. And I recognize that Davis sort of pulled from Campbell, but rather than referring back to instruction 58, giving like a note or a new instruction, I'm not sure that that's significant what you call it, but.
Well, and I mentioned that only to suggest that here, I think the court in its own comments was concerned and didn't want to coerce anyone, so they tried to do it in the least coercive manner possible, which was, in their view, a note rather than a supplemental instruction that would draw attention.
Less coercive to say, reread your instructions, specifically instruction 58, right?
I guess I would say I suppose so, and in fact, the court in a previous instance where it did not give the Allen charge did just that, said please reread the instructions. I think to your earlier question, though, I would not concede that it would be an abuse of discretion going forward. I think Davis is the example that my position is correct, and that as far back as Campbell, the Iowa Supreme Court was saying, we have this kind of model ABA instruction. We think it could be given just as part of the instructions given to the jury at the closing of the case. That would alleviate any concern that this more recent instruction is going to be weighed more heavily and be coercive. That hasn't been happening all the way up until when the Supreme Court decided Davis last year.
Piper, right?
Your Honor, and I apologize, I don't remember offhand.
Instruction that was given with the rest of the set.
Okay. And that may be, but I would still say that given the result in Davis, the Iowa Supreme Court again has said that that is acceptable to give that supplemental Allen charge, although it again, as you noted, reiterated that best practice might be going forward, to just simply put that instruction in at the close of the case so that some of the coercion could be alleviated further.
Counsel, could you comment on the same question I asked Mr. Spees on the rapid succession of these last 3 instructions to the jury on the Thursday, like 11 o'clock, 10 o'clock, 11:15, and 12:08? Do we take that in consideration on the coercive nature of those instructions?
I would say, Your Honor, that I don't think it is meaningful here, and that would be for a couple of reasons. Number one, I think all of it, from my perspective, was jury initiated. They kept asking questions and sending more notes. The court had to say something back. And I think if you look at the court's progression in its position, first saying I'm not going to give it, and then coming back, also immediately before it actually gives that final note with the Allen charge, you see in the record that it retires to chambers, presumably, to review case law. And I think specifically, the parties had asked, or it did review the Parmer case, which was a 2015 Court of Appeals case. And so I think you see in that progression kind of its opinion evolving, and then in the end it says, well, I found a recent case saying that it is okay to give this charge in this scenario.
Less than an hour after the most recent statement from the jury that they are deadlocked, correct?
You're saying from the first or the most recent?
11:15 from the jury, and then the Allen charge was issued at 12:08. Is that correct from the record?
In Your Honor, because of the tight timing, I'm not going to be able to say exact minutes. But I would say that I think, again, because you can see the progression of the judge's decision-making, that in the end, kind of the tightness of all those decisions is not an important factor in this case.
Now, as we talked about with Mr. Spees, there was still continued expressed hesitation from the trial court. Is that significant to our discussion or our resolution of this, or is that just kind of that's an interesting detail in our fact pattern here?
I think it's an interesting detail, and I would say a couple things on that. First, I think realistically what was happening is the court was just thinking out loud through the options, right? Any court that's facing a potential Allen charge is in kind of a not ideal situation. They have a potentially hung jury. They'd prefer for that not to happen, but they don't want to coerce them. So really all it did was talk through, my best option here is to give this charge. If it gets them to begin their discussions, we might get a verdict. If not, we're in the same place we are. And the last thing I would say before, if I can have 1 second to finish, is certainly it doesn't work the other way. You know, appellate courts don't uphold a court simply because it says it thinks it made the right decision or that it was very confident. So I'm not sure you can do the reverse and discredit anything where they show some skepticism or doubt.
Before you sit down, when we apply the prejudice standard to an Allen charge case, do we look at just the surrounding circumstances of giving the Allen charge, or do we look at the strength of the state's case as well?
I don't know how you could possibly look at the strength of the state's case or not, because implicitly in all these cases, the state's done enough to convince 10 or 11 or however many people, you know, for us to then say which group is more correct in assessing how strong something. I think you end up in basically the same situation in all cases, so it's hard to then read tea leaves about how good of a case it was or wasn't. I think here it was strong enough to ultimately get a conviction on second-degree murder, and I would ask that the court uphold that conviction. Thank you.
Rebuttal.
Thank you. I'll be brief. You know, the question here is whether the court abused its discretion, and I've always bristled at the notion of abuse. You know, all judges do their very best, but here we have something that's I think really, really unique. You know, when Judge Bruns first said, "I think giving an Allen charge in this situation is inappropriate. If I do it, it's going to be an abuse of the defendant's right to a fair trial." There's an exercise of discretion right there. And the judge realized at that point, if he were to give an Allen charge, in his opinion, being a barometer of abuse, it would be an abuse of discretion. What changed between that point when he said, I shouldn't do this, it's not appropriate, and the second time when he said, I still think it's inappropriate, or I've got reservations about it, but I'm going to do it anyway? Nothing changed other than getting another note from the jury saying, we are stuck, this juror will not deliberate. And so, in my estimation, based on the lay of the land and the totality of the circumstances, is how you judge abuse of discretion.
That our standard of review is abuse of discretion, given sort of the constitutional underpinnings of not having a coerced jury?
Yeah, I do. But I think that the measure of discretion is tempered by the importance of the constitutional issue at stake here. And there's no doubt that the judge was concerned about Mr. Blahnik's, now Mr. Church's, right to a fair trial and to have his verdict decided by a unanimous jury. And so, given the gravity of the constitutional issues, I think that is a measure to be used in the decision about abuse of discretion.
Can I also ask you about another factor that the Supreme Court emphasized in Davis about polling the jurors, and that if we poll all the jurors and they, say, yes, that's my verdict, can we just rely on that?
I think that's a pretty weak measure. First of all, as I pointed out in my brief, this was a situation where the case was covered by expanded media. It was intensely emotional from the beginning to the end, and to have 12 jurors sit in the box with cameras rolling, not on them, but on the court, to say, in the face of that, after 2.5 days of deliberation, high tension, to have one of those jurors say, you know what, this is not my verdict. I think that it's extremely difficult, and having looked at a lot of jurors,
They wouldn't necessarily have to say, no, it wasn't my verdict, but I mean, presumably the one holdout might have said, it's my verdict, but I felt like I got pressured into it, or something like that. And I've never seen that happen. I'm not aware of any case where a juror has ever said that in response. I assume it's happened, or there would be no purpose of polling jurors, but would it have to be as strong as saying, no, that's not my verdict, as opposed to, I think there's even some suggestion that there was about like hesitation, where somebody, like there was even a pause that somebody picked up on, or some feeling of reluctance.
trial lawyers love to read the faces of jurors and try to distill what's going on in the minds of those jurors. But it's extremely difficult for anybody sitting in a jury box surrounded by 11 angry men and women to say, you know what, we're here and I'm going to change my mind. I just think it's, given the human condition and human behavior, I think it's a weak test of whether or not somebody's going to say, this was not my verdict, and I crumbled, I capitulated because of what you just told me, Judge. I think it's a weak measure. So, yeah, I think given the unique circumstances of this case, but one holdout juror having been fingered by her, 11 other jurors, that this distinguishes the case from the other cases the court has considered in the past. While I'm reluctant to say any judge abuses his or her discretion, I think this is a situation where the judge's instincts at the outset were right. This was not a situation where an Allen charge was going to instill any new train of deliberations.
And the fact that the jury came back with a second-degree murder verdict.
I don't think that that's much of a factor at all. You know, whether this was a compromise verdict and the one holdout jurors would be able to say, okay, I'll vote, but only if we vote for a lesser verdict on the murder charge. I think that would be speculation. It doesn't add much to the debate. Thank you very much.
Thank you both for your very helpful arguments this morning. State versus Church will be considered submitted, and a written decision will be forthcoming as soon as possible. And we will now have a panel change.
Case up for consideration is Krogman versus Iowa Public Employment Relations Board, and we are ready for arguments.
Please the court, counsel. I'm Charles Gribble. I'm here on behalf of Derek Krogman. Mr. Krogman was terminated by the state of Iowa. He appealed his decision to the Public Employment Relations Board, who upheld that determination, as did the district court. Mr. Krogman was employed by the state for a period of 24 years as a residential treatment worker. He, during that time, had excellent evaluations. He had no prior discipline other than missing work once or twice.
Regardless of your stellar performance history, that depending upon how egregious the rule violation was, that could warrant kind of undo all that. You know, my mom always said, you know, one indiscretion can ruin a lifetime of, you know, good reputation that you built up, right? Isn't that kind of the same thing here?
Your Honor, but in this case, we are looking at simply just one instance that occurred on October 18th, October 20th of 2018. It was limited to a situation where he should have and did not apply what's known as the MANT technique to block and redirect a resident who had a history of spitting in her
hands and then rubbing that spit in her hair. And instead of blocking and redirecting, he did slap her wrist or hand once or twice. And based on that then, and based on that incident only, he was terminated from his employment. Now, the issue here with respect to just cause is set forth in Chapter 8A, 415-2B, and states that just cause is necessary for any discipline up to and including termination.
Have indicated that that determination is clearly vested in the discretion of the agency, the Public Employment Relations Board. And I wonder if you could address the standard that goes with that clear vesting, the irrational, illogical standard. Why should that not apply here?
Because, Your Honor, in 2017, the Iowa Supreme Court in United Electrical determined that PERB no longer had the power to interpret its own statute, and that now was a question where they could only administer their statute. It's true, as you said, that if they had the obligation and the right to interpret their own statute, then, of course, you'd uphold the decision if there was substantial evidence for it. However, since they do not have interpretive authority, but only authority to administer, as of United Electrical, the question is for correction of erroneous interpretation of law. And in this case, the law is set forth in Chapter 8A. It is just cause. It also includes within just cause the concept of progressive discipline. And with respect to your question, Judge Ahlers, we don't think that this is the exception where progressive discipline cannot be used because it was a singular incident after 24 years of excellent performance, good evaluations, no prior discipline. So it's a singular incident where progressive discipline could and should have been utilized in this particular case.
The section of your brief talks about prior precedent. When I review those cases, they seem to be distinguishable from Krogman's case because it did not argue or did not concede any intentional physical punishment, more like this was an accident, I didn't mean to hit the person, or I accidentally kicked. And in this case, Mr. Krogman admitting to striking the resident twice and loud enough that the person in an adjoining office could hear that. Is that distinguishable under the prior precedent?
We don't believe so, Your Honor, at least not to the degree that the court and PERB have held that it is. I think the case you're probably referring to is the Cole case. And in that case, it was a case where the resident treatment worker stuck out his leg and made contact with the resident, precluding the resident from leaving. In that case, the court found that, and PERB found, excuse me, that it was not intentional, that there was no harm to the resident, that it was a first offense, that while the MANT techniques were not applied, he had a perfect record of good performance, no prior discipline, and on that basis held that the appropriate remedy was 3 days. So
to intentionally slapping the resident, correct? Whereas in that case, he indicated it was an accident.
well, in this particular case, Your Honor, looking at the confidential appendix, page 6, what he states and what the state bases the discipline on is simply his admission that he did, in fact, strike the resident once or twice on the hand or wrist. That's it, and that's the basis for the decision. As far as intent, no, I think he's saying he can't. In fact, his transcript of his investigations at page 46 of the appendix, in which he states that he has never abused any resident, and as to this incident, he really can't explain why, what happened. It was just apparently a reflex action, but there's nothing to indicate it was intentional, that he did it, he just was reflective in how he did it. He shouldn't have done it.
There's no dispute, though, is there, that it was intentional in the sense that this wasn't like, you know, his hand slipped, or like in Cole where the guy stuck his leg out to try to block and then the person ran into the leg type of thing. I mean, he intentionally struck her, right?
Well, he did strike her. I think the element of intent, though, I would disagree with you on that, Your Honor. I don't think that in this case, given his prior history, it was just a reflective action, like a child is doing something and you strike their hand, you don't really mean to do that. You just do it. It's hard to explain, and that's what he said in his investigation.
Related to that, if I'm understanding the record correctly, when his supervisor called him in after he'd slapped the resident, your client said something along the line of, "I can get fired, don't turn me in." Even though it's a fairly short sentence, that seems like a really loaded admission, because it seems to establish that your client knew the rule, knew that he violated the rule, and knew that termination was an option for that violation. Doesn't that somewhat undermine your argument that progressive discipline, because your own guy is admitting that, hey, this is probably a fireable offense, what I just did, as opposed to, I don't think that would be the reaction if, let's say the rule was you're not supposed to chew gum on duty, and he gets caught chewing gum, and he says, hey, don't turn me in, I could get fired for that. He probably wouldn't say that, because nobody thinks they're going to get fired for violating the gum chewing rule. But he's acknowledging that what he just did, immediately his mind went to, I could get fired for this. Doesn't that kind of back up the PERB's side of it, that's why progressive discipline isn't in order?
Only in part, Your Honor, because I think we have to look at the actual conduct itself. There's no question that he did panic. There's no question that he did admit that he struck the resident. There's no question that in the few first moments after that, he said, please don't turn me in. I'm concerned about my job. He did say that. But in later, when he was investigated 3 hours later, his story was quite different. It was very cooperative. And I think what we have to look at is, does this singular act justify termination? It's not a question of whether, like in Cole, there was a 3-day suspension, whether here maybe there should be a 10-day suspension or a 20-day suspension. But the difference is really great between a 3-day suspension and permanent termination of someone's employment.
Fireable, doesn't that put this facility in a bad situation? Because let's say that he has whatever caused him to do it this time, causes him, whether it's a reflex or instinct, whatever you want to call it, and he does it again, and all of a sudden the person's hurt, all of a sudden they get sued, and it turns out he has a track record of this, and he didn't get fired for it. Isn't the home exposing themselves to potentially more liability? I mean, does that come into play at all in terms of deciding whether this should be a fireable offense?
Case, I would say, Your Honor, no, that does not apply, because it would be sheer speculation. Given his 24 years of good service, that this has never happened previously, the only argument I see for terminating his employment would be speculation that he might do something again, which would be true in every case of discipline.
I want to equate this to a dog, but I'm thinking you could have a dog that's never bitten anybody for years, and then after the dog bites somebody the first time, you've got a real problem on your hands at the risk of the dog biting the second time, right? Even though the dog had a long history of being a docile, non-biting dog.
Your Honor, in the area of employment law, however, really the progressive standard is so ingrained in the process. It's part of the state's own rules that say that progressive discipline is intended to improve performance, not punish, and that the purpose is through a series of increasing steps, an oral reprimand, a written one, a suspension, perhaps some retraining, that all of that is utilized before you go to termination, that's only a last resort, a last step in the process. So here we think that PERB did show that there was some discipline that was appropriate. They did show that he violated a rule. They did show they did an investigation, but they did not apply progressive discipline, and we don't think speculation is enough of a reason not to apply it. And all they said, they considered his past history, his good evaluations, his performance. In reality, I don't think we'd be here if they did.
So you will have additional time.
Good morning. May it please the court, counsel. My name is Tessa Register, and I'm here on behalf of the Public Employment Relations Board. I want to start with actually how we should be thinking about 17A, because I think we've heard some misstatements today. So judicial review is not a free-for-all. You don't get to challenge agency action based on any theory you want. The legislature has created discrete lanes with discrete inquiries, and that sets this court's bounds. And what we've heard today is the conflating of several lanes at once. So for example, substantial compliance to support a conclusion is not a ground under 17A. That conflates F and that conflates M. Deference to the agency's ultimate conclusion is not a ground under 17A. That conflates C and that conflates M. And so I want to make sure that as you're going through this appeal, that you're making sure we're in the right lane. And as we go through each of these lanes, I think you'll see that PERB's decision should be supported.
Address the argument that United Electric requires a certain standard of review and forecloses others.
Electric has no role in this appeal because this is not a Chapter 20 case. This is not a collective bargaining case. We're not interpreting Chapter 20. C only comes into play when we're interpreting a statute and the party doesn't like how the agency interpreted it. But here, the only thing being interpreted is just cause. That's in 8A, not 20. And in interpreting just cause, Krogman has the exact same interpretation as the agency. We all agree that just cause is the totality of the circumstances inquiry that specifically focus on the 8 factors. We actually have the same block quote in our briefs. So there is actually no dispute on how we interpret just cause. The conflict here is the application of that interpretation to Mr. Krogman's particular situation. And that is M, that's not C. And so the majority of the brief talks about C, but C has no role in this case because there's no dispute on what just cause should mean. If PERB had said just cause should be interpreted to be any non-discriminatory reason, and they said, no, we think it should be a more worker-friendly totality approach, then we'd be in C territory, then we'd talk about deference. But that's not what we're here today to do. There's no dispute over what just cause means. It's just whether the just cause standard was met in his particular case. That's M. And then briefly as well, C is in no way preserved for your review. In their petition for judicial review, C is listed in the petition, but in their brief to the district court, they abandoned C. They also abandoned D. They said they only are seeking judicial review based on F, G, H, M, and N. And so the district court only ruled on F, G, H, M, and N. And when they got that ruling only addressing those, they didn't move to expand the ruling to get a ruling on C. And so for matters of error preservation, C is just not in front of you. But again, even if it was, we're not talking about any dispute about what just cause means. We all agree. And so I think taking a generous view of their brief, that the two main grounds, the two main lanes here are M and H, right? Whether they applied the law to the facts correctly, and then whether it's consistent with prior precedent, that's M, that's H.
That prior precedent, when I was reviewing the cases cited by your opponent, I couldn't find any cases where physical discipline was found not to fit into that to jump from the progressive discipline to termination. And in this case, it wasn't just one slap, it was 2 slaps, loud enough to be heard. Do you believe that this ruling by the district court follows the precedent?
Absolutely, and I think when we're talking about precedent, we're talking about PERB's prior precedent, and it's their burden to show that we acted contrary to it, and the only real challenge they make is the Cole case, and for the reasons we discussed during the principal argument. The Cole was completely distinguishable, particularly the willful element, the intentional element, and the good reason for sticking your leg out, right, to stop someone from leaving the room unclothed. That is not someone who intended to even make contact. The contact was incidental, it was minor, and so that, I think, is just factually completely different than someone who fully intended to slap not once but twice. The idea that it wasn't intentional, we're talking about intentional contact, that was not inadvertent. That was not I stuck my hand out to do something else and we came into contact. The slap was intentional and it was twice. And I think that's really egregious.
The fact that Krogman admits he doesn't know why he did it, does that raise the concern as well to jump to termination versus progressive discipline?
And I think when we talk about the lengthy employment history, I don't concede that that's always a mitigating factor. I think that can be an aggravating factor. And here, I think that's an aggravating factor. Someone has 23 years of experience with these type of patient populations. Someone has 23 years of training, of experience, of knowledge. This is someone who, above all employees, should know how to handle this situation. And I think the context of this particular slap is actually really important. When we read prior PERB cases, sometimes someone is grabbed from behind by a resident, sometimes someone is surprised by a resident, and there's a knee-jerk, there's a reflective action that might actually end up being abusive or an improper contact. And we look at that a little bit differently because it was reflexive and not intentional. Here, this is someone who was behaving in conduct, putting a saliva in their hand and putting in their hair. They did it so frequently that Krogman noted it in the person's file. This was completely foreseeable, predictable conduct. This is not something that caught Krogman out of surprise. This is something he should have been ready for. This was in the person's notes. And so the fact that he encountered predictable, foreseeable behavior and responded to it with an assault is egregious. And I think that really takes us out of the progressive discipline because someone who has 23 years of experience should not encounter foreseeable, predictable resident behavior with an assault. And I think that supports the egregiousness.
If any, does the Department of Inspections and Appeals proceeding outcome have on us? Is the reference to that finding in the record just an, oh, that's an interesting kind of thing, or does that actually have some sway on what we do here today?
It's relevant to an extent. I think it matters that they found it to be elder abuse. I think that matters. That they found it themselves that he shouldn't register. DIA has a different purpose, or that inquiry has a different purpose than the employer, right? And so when you're put on that elder abuse registry, you're done. You're not a nurse anymore. I do some work with the nursing board, and there's just no way, right? And so when you're on that registry, it's not that you can't work somewhere. You basically can't work anywhere. And so we want DIA to be a little bit judicious in who they put on that registry and to be careful. But from an employer's perspective, if I lose trust in my employee, that's it. They don't have to work here. It doesn't mean they can't work somewhere else, but they can't work here. And so they're really different inquiries, right? One is asking, are you safe to work anywhere? Here, do we trust you to work here? And so it's instructive to the extent that it confirms that this is correct, this was elder abuse, but their finding that it's not likely to recur is not particularly instructive because from the employer's perspective, someone with 23 years of training have been told for 23 years that this is unacceptable and did it anyway. That's someone we lose trust in, and that's someone that can no longer work here. So looking at M and the factors here, I think there are a couple more points I want to make. I think there are some mistakes you don't get to make twice, and this is one of them. This is someone who, the resident is nonverbal, the resident cannot communicate in the form of questions and answers, the resident does not have typical reactions to being upset. And so the discussions about the resident's demeanor afterwards are not instructive and contrary to that resident's treatment plan and diagnoses. This is someone whose disabilities make them exceptionally vulnerable to improper touches and improper contact. This is someone we have to protect. And this is someone that was known to Mr. Krogman to have these disabilities. And that the fact that he chose to react to this vulnerable person who engaged in predictable and foreseeable behavior by slapping her not once but twice is egregious grounds for termination. Those are the points I want to make. If anyone has any other questions, otherwise I'll sit down a little early. All right, thanks.
Very few people that can talk faster than I do, but I think you do it, so
I wrote slow up here, if it helps.
The decision in United Electrical was a decision involving the Public Employment Relations Board. The Public Employment Relations Board does handle all appeals that arise when a state of Iowa employee is disciplined or terminated. So United Electrical does apply, is controlling here. And so
that it does the standard of review under 17A really swing the day here?
I think it does, because under one, all you need is substantial evidence to uphold PERB's decision. Under the other, you're really looking for whether or not they misapplied the law, which in this case is just cause. Now, I agree there's some overlap there because even under a substantial evidence test, we would say there's enough evidence for some discipline here, but not enough for termination.
What about the argument that C really applies to an interpretation of just cause, and this case is not about an interpretation of just cause, but simply about an application of law to facts?
Well, it is an application of law to facts, but Your Honor, I do not see the difference there. It still would be interpreting then under C the law itself, and the law set forth in 8A 415-2B, which is just cause. And that would be what is to be interpreted here in this particular case.
You didn't even argue that at the lower proceeding. Even though you listed it in your petition for judicial review, it wasn't listed in your brief in support.
But the issue is preserved, we believe, under both Butler and Robinson, which if the court applies the wrong law or the wrong standard of review, that is reviewed. And in this particular case, the court did identify the issue, did discuss it at length, and did render a ruling. So we believe the issue is preserved. To call this, however, an assault, I think really misstates what happened here. We're talking about a slap on the hand or wrist. That's all it is. And the discipline was based, if we look at Appendix
6 confidential appendix. The whole discipline has to be based, and the whole ruling based on what the state says in their letter of termination. All they have in their letter of termination is the admission by Mr. Krogman that that's what he did. So the question is, someone has a bad day over 24 years with good evaluations, with no prior discipline, are you going to terminate someone when the state's own policies require the use of progressive discipline?
Argument that his length of service is actually a negative fact because he, of all people, should have the training, the experience, the need to be kind of a mentor and a leader for other people there, that he, of all people, should not lose it that day, you know, and do that.
Certainly, with respect to that, we would say that that would certainly stand on its head all the principles used by PERB over the years, because in general, they always do consider the years of service, seniority, the lack of prior discipline, good evaluations, and are more likely to say that this conduct was an aberration, just not reflective of the person's overall work performance. And in those situations, the individual sure should be disciplined in some way, letter of reprimand, a suspension, some retraining, but not terminated. There are many other avenues that the state could have utilized and did not in this particular case.
Your response to your opponent's argument that this was predictable behavior from the resident that he should have been prepared for versus a resident coming at him from behind where some unwanted contact may have occurred.
That's why I think, Your Honor, that to say that the action was just reflective, and that's what he's saying. When he's asked why he did this, he said, you know, I don't know. It's just out of character for me. I've never done that in 24 years before. I think he saw this. I think much like you see someone doing something wrong and you slap their hand, it does make a noise. And I don't think it was intentional. I don't think calling an assault is in any way fair to what took place in this particular case. Certainly, I think the Department of Inspections and Appeals, even though that's not what an issue saying it was, certainly minor, isolated, unlikely to reoccur, based on the facts that we have in this case, is certainly the correct outcome.
Do you think that has any, do you think that's just spice in this case, or do you think that really has any bearing, the DIA decision have any bearing on our decision?
And an agency looked at it and made that conclusion. Certainly does have some bearing on that. I agree the underlying issue still is whether there was just cause in this particular case, Your Honor. Thank you.
The case of Krogman versus Iowa Public Employment Relations Board is now submitted, and we are ready for arguments in Jacobs versus State.
May it please the court, counsel. My name's Nate Stout, and I'm here on behalf of Fantasia Jacobs and her children. This is a gross negligence case. This case went to trial, and at the conclusion of plaintiff's case in chief, the trial court dismissed the entirety of plaintiff's claims on directed verdict. We're appealing that decision. The issue before the court is whether or not there is substantial evidence to support each element of Ms. Jacobs' gross negligence claim. We submit that there is, and that the trial court erred in holding otherwise. On August 3rd, 2017, Ms. Jacobs was attacked by a high school student at knife point in and during the course of her employment with Iowa Vocational Rehabilitation Services. Prior to that attack, the student had a documented history of violent, unpredictable behavior and reported extreme sexual compulsions, including fantasies of rape, which he described as uncontrollable. The extent of that student's erratic behavior and sexual compulsions are detailed in his medical records, and we submit that those records speak for themselves. Ms. Jacobs' supervisor, Suzanne Friess, read those medical records prior to the attack. This case is about what Susan Friess knew after reading those records and her decision to do nothing given what she knew and knowing what would happen. We think this case really boils down to two questions. Did Susan Friess know what was in the medical records? And if yes, did she know or should she have known that Ms. Jacobs would be working with him alone, unaware, and unprotected? If the court finds that there's substantial evidence to support an affirmative answer for each of those questions, we submit that Susan Friess's decision to do nothing amounts to gross negligence under Iowa law. When we look at the first question, did she know what was in the medical records, or in other words, did she know the full details of what's contained in the records? She admits that she reviewed the records and admits that she spent approximately 3 hours doing so, in addition to writing the eligibility determination itself. At trial, for the first time, she qualified that admission and said that she might have skimmed the records. The implication being that she might not have known the full details of what's in the records. In other words, didn't know that he was dangerous. Despite that qualification, she doesn't deny that she read the records. She's pretty much, her testimony is, I don't know if I did or didn't, I don't know what I knew then. But to accept that qualification requires a credibility determination, which we think is in the purview of the jury.
Counsel, could you address the fact that at the time the high school student signed up for this boot camp where the assault occurred, was Friess even working at that time for the state?
The testimony from Ms. Friess is that she had retired after the boot camp, after he signed up for it.
Before the boot camp.
That her testimony was that she retired and that he signed up for the boot camp after that. But addressing that, the issue is whether or not she knew that Ms. Jacobs would be working with this student alone. The boot camp is a degree or a vehicle in working with the students. Her testimony at trial was that she knew after that eligibility determination was made, she knew that the next step was that you meet with the job candidate and you start working on an individual plan for employment and then start fulfilling those goals, and that's going to continue indefinitely. And she knew that those types of meetings and working with the job candidate specifically, her testimony at trial was that it commonly happens alone. And so the whole issue with her is that she knew or should have known that.
This isn't the same standard on the gross negligence, isn't it? Don't you have to know of the danger? Not that the danger is common.
For the first element, you have to show actual knowledge of the danger. And then for the second element, that's knew or should have known. So, our position is she certainly knew about the danger because she read the records. So she knew this individual student was dangerous.
The suggestion that most of the clients, or whatever the terminology is, not most, but a lot of the clients had behavioral issues, mental health issues, had similar kind of backgrounds to what this particular person had. So it's kind of like if everybody's a danger, then nobody's a danger type of thing. It's like you have to, I think like the prison setting, it's like, all the prisoners are dangerous, right? Potentially, we don't have to single out individual ones and say, hey, we really keep a lookout for this person. Maybe that's a bad analogy, it just popped into my head, but how does that fit in? Because that seems problematic, that she knows, your client knows that she's transporting people that have behavioral and mental health problems, and what this guy did is something that some people with mental health or behavioral problems do. So why isn't she just inherently on notice that type of thing could happen?
So to get the program itself, it requires some level of disability. It could be a lot of different things. It could be physical, mental, emotional. It's kind of across the spectrum there.
Suggesting that every client has these types of issues, but certainly some do, right?
Some of them have histories of violence or criminal records, that sort of thing. That's why we think that this distinction in terms of this particular student is really important, because dealing with somebody that has, a history, a criminal record that involves some level of violence is one thing. But what's important to remember is that you can distinguish that from these types of self-described uncontrollable compulsions. And essentially, he said to his provider, although I don't want to hurt anyone, I'm concerned I'm not going to be able to control this. So we would distinguish that level of danger. And
To follow up on that, there is this assertion about the sexual compulsions. The state argues that sexual compulsion was not a component of the assault, so that shouldn't be considered. Could you address that argument?
Sure. So we don't have to, from a gross negligence standpoint, we don't have to prove his mens rea. And I don't think that anybody, he individually might not know what his particular motive was, because his position is that he had completely blacked out. But, when you're having these self-described blackouts where you don't know what you're doing one way or the other, and you don't know when they're going to happen, and essentially saying, if I have one of these and someone's in my path, although I don't want to hurt anyone, I can't make any guarantees. Whether or not, we think that the evidence shows that there was a sexual component to it, because, some aspects of it were, the state has suggested, well, he was just trying to steal the van and escape. And based on his actions, he held the knife to her throat and indicated that he wanted her to take her to a different location where another man was waiting. And if he wanted to escape, he could have easily just asked her to leave the van.
Any number of reasons for that, right? I mean, maybe he wanted to, steal her purse. Maybe he wanted help with his buddy when he got control of the van. I mean, nothing was said or done that indicated that it was sexually motivated, was there?
I think you can draw the inferences from.
We can speculate about why he wanted to go to this secluded place where his buddy was, or why he was saying that's where he wanted her to go. But there's nothing he said or did that indicated that that was sexually driven. Certainly one of the speculative things that we can come up with is that he wanted to do something sexual, but it could have been something not sexual as well, right?
But I think the most important issue is that he's just inherently dangerous. And I mean, you can pick that up from the record. So whether or not there's a sexual component or not, we maintain that there was. But
isn't that the crux of the stuff in his reports that you're criticizing her for not divulging to your client, is the sexual compulsion component?
part of it, yes, because that was an ongoing thing that he was experiencing, but it could.
But if that's the underlying thing that you think warranted the warning, because that's what I understand. Basically, you're saying you should have given this lady a heads up that this guy was dangerous, right?
Take it under the totality of the circumstances, that he's just inherently dangerous in many different ways, and the claim is that she failed to act altogether. So the state is going to make arguments about, hey, this is a warning, so it falls into the misrepresentation. It's more than just a warning. So there's no safeguards at all for handling this particular individual, and with those, knowing that there's no safeguards. I see my time is up. Can I finish my point? So, the extent of what's in the records and what she knew differs from what Ms. Jacobs was told at the intake. So the information that was provided to her indicated that he had improved. The quote was from him, "I know how to handle myself." The records have a lot of different things in them that show that he has a history of lying, noncompliance, has these uncontrollable behaviors. All of those things taken in totality, you simply can't allow your subordinate to work with him alone, unaware, and with no safeguards.
Thank you, counsel.
May it please the court, counsel. We just had a lot of discussion about what was in this individual's medical records. I think it's important to zoom out a little bit because this case isn't just about the medical records. And I think it's important to zoom out to understand the timeline of what happened. So let's talk a little bit about the timeline. At trial, Ms. Fries testified that it was her understanding that they did not transport students one-on-one while she was employed at IVRS. And in terms of the contention that an employee is going to meet alone with a job candidate, the trial testimony was uncontroverted that alone meant in a public place, in a courthouse, in a McDonald's. There's no testimony in the record that IVRS was transporting individuals one-on-one while Ms. Fries was employed. And as you review this case, I think this is not an ordinary negligence case. This is a very specialized case that has an extremely high burden. You can look through all of the appellate cases. The court will always start with this is a high burden. It's often you'll see many cases are decided on summary judgment. Many cases are decided on directed verdicts. That's normal because it's a very difficult case to prove. And the reason it's a difficult case to prove is because that's why we have workers' compensation, right? So workers' compensation exists to remedy an employee who's injured at work without regard to fault. That's what happened here. An employee is injured at work, fault doesn't matter, the employee recovers.
Bargain, right, that they talk about a work comp that, the claimant doesn't have to prove fault, but on the other hand is more limited on the types of recoveries that the claimant can get.
That's precisely right. And the court is clear when they talk about gross negligence cases that is the bargain, right? There's no liability determination in comp. The question is whether you were, working within the scope of your employment, you're injured at work, you get to recover. And opening up liability on facts like this would cause employers to have to, they're going to be responsible for much more than comp. So not only are they going to have to, have workers' compensation insurance, but they're also going to have to, hire lawyers to defend against these kinds of cases, and they're going to be exposed to liability that the comp scheme explicitly did not want to happen. And so this is tried to expand beyond the scope of the comp scheme.
Address the two-element test set forth in Thompson. Are you conceding that she had the knowledge but did not meet the second element of the Thompson test? The probable versus possible?
Yeah, so most courts decided on the second test, which is knowledge of the probability of an assault, right? So that the defendant had knowledge that an injury was the probable result of that defendant's conduct. And so that's what most courts decided on. But in this case, I am not conceding that Ms. Fries had knowledge of a peril. I understand that it's plaintiff's position that this kid is inherently dangerous, but that's just an argument. What did the evidence show? Well, the evidence showed that, and this came from plaintiff's testimony at trial, that there is nothing unusual about this student. And to the extent that there's reliance on the medical records to say there's some sort of sexual compulsion, we already talked about it when plaintiff's counsel was arguing that, there's no evidence that there's any sexual component at all.
What about his argument that the sexual compulsion isn't really required, whether this was a sexually compulsive act or it wasn't? This kid was basically inherently dangerous, not just because of a sexual, like rape fantasies, but just in general.
Sure. So the question is, what did the trial record show about how dangerous this kid was? The trial record showed that he was no different than any IVRS candidate. And it comes from plaintiff's own notes from when she did the intake, right? During the intake, she notes that he has a history of violence. She notes that he's charged with sexual assault. She notes that he has a history of aggression. So this isn't something that, I think what the plaintiffs would have to show was that there's something in these medical records that is different than what everybody knew, or somehow made this kid different than your typical Iowa Vocational Rehabilitation Services candidate. And there's zero evidence in the record that there's any difference, even in these medical records, versus the medical records of any other candidate.
respect to those medical records, what does the record actually reflect with respect to Ms. Price's level of knowledge of those records?
So the record reflects that Ms. she has no independent memory of reviewing these particular records. However, it was her practice when she would review medical records is that she would skim the records for diagnoses. And so I think that's important because what she's doing when she's reviewing the medical records isn't, I need to figure out whether this person is dangerous. What she's doing is deciding whether this person has documented diagnoses that would create barriers to employment, that are disabilities. And she testified that she's got an RSA code book that she has as she's reviewing these records. And so she's going through the medical records, she notes a diagnosis, this has a certain code. Okay, once you get to 3 documented disabilities, that's the highest level of eligibility, and you're done. So the record, in terms of her knowledge of what was in these medical records, the only trial testimony was that she would skim the records for these diagnoses.
Counsel, what weight, if any, do you think plays into the directed verdict about the timing of her retirement and the signing up for the boot camp and her knowledge of that?
So that's, again, a lot of these cases come back to element 2, which is the probability that an attack is imminent. And so I want to focus on 2 aspects of that: the probability that an injury is more likely than not to occur, and then the imminency of it. So in terms of the time period, I mean, that goes right to imminency, right? I mean, Ms. Price does the intake on March 7th, 149 days before this attack happens. She retires April 20th, which is 105 days before this happens. And so, and the contention is that, well, Ms. Price knew that Ms. Jacobs would immediately meet with the student. Ms. Jacobs did immediately meet with this student after Ms. Price retired, and it was totally a non-issue. And that was the extent of what Ms. Price knew. So that goes to imminence. And in that interim period between when Ms. Price retired and when the attack happened, I think in the record there are 6 separate instances where Ms. Jacobs picks up the troubled individual, transports him to the summer boot camp program, spends the entire day with him, transports him home, no incidents. And then in terms of the probability, because this is what plaintiff has to show, and this is usually where plaintiffs fail in these types of cases, to suggest that Ms. Price knew that an attack was probable is just totally contradicted by the record. She had no knowledge that anybody was going to be driving any job candidate alone. She had no knowledge whether this particular job candidate was even going to follow through with services with IVRS. She had no knowledge that this individual was going to sign up for the summer boot camp program because he didn't sign up for it until after she retired. She had no knowledge that this individual was ever going to be alone with the plaintiff. And she had no knowledge of it's impossible to try to task her with the knowledge that this person was going to act in a certain way. And I think that's important in the gross negligence context too, because when you look at the other cases that are all cited in both of our briefs, we're talking about cases where employees are dealing with caustic chemicals. We're talking about 70-ton presses. We're talking about, blades, cutting meat in these industrial, inherently dangerous situations. And we're talking about the world of physics. So we're talking, everybody, it's reasonable to say that everybody knows that if you put your hand under a 70-ton press, you're going to get hurt. But it's not reasonable to say you can somehow predict, based on a cursory review of medical records, that this individual is, number one, going to be in a situation to attack somebody, but that even if they were, that they were likely to attack somebody. And in terms of the burden, I talk about the 70-ton press because this is the Thompson v. Bolkin case. And I think the facts of the case are really illustrative of just how difficult it is to prove a case like this. So as I said, there's a 70-ton press, and this employee is directed to use a screwdriver and push a sheet of metal through this 70-ton press. And there was evidence that the supervisor, so it's similar here in that it's a supervisor, knew of previous injuries, knew that previous people had had their fingers severed and had other minor injuries. But the court found that because those injuries didn't happen to happen in this particular press, that was not enough. So if that's not enough to say that, Ms. Price had knowledge that a based on a cursory review of the records, that, 149 days later, this kid is going to attack somebody. I mean, it's just totally contrary to all the case law, and I can see that I'm out of time. Thank you.
Okay, so a couple of things. So I wanted to talk about the timing. So the state talked about, hey, there was this huge amount of time, they said 100 days that passes in between the eligibility decision and the attack. An important thing we want to distinguish with that is the amount of times that Ms. Jacobs actually worked with this individual. So if I remember correctly, it's only 7 times. So although it's 100 some odd days, you really got to look at the amount of times that she worked with him. So within 1 week's worth of meetings with this individual, he attacked her. And we liken that sort of scenario to the Swanson case, which is the flagship case for gross negligence in terms of favorability for the plaintiff, and that this individual was in a situation where they were working in a dangerous condition without the safeguard, and the court said that each day that they went in and worked made it more probable that something was going to happen. Basically, each time you keep going in, yeah, you may get lucky and something doesn't happen, but the probability that something is going to happen continues to increase each time you work with that particular machine in that case. Going to the case law in terms of, most cases deal with machinery, a press, or whatever the case may be. One thing that we want to distinguish from that is that a press cannot tell you that they are dangerous. The human element here is that he directly said to his providers, I'm not going to be able to control myself. If I have a blackout, someone's basically going to get hurt. So
difference on that, if you've got a dangerous machine that the guard's not on, or it's acting up and acting unpredictably, and if it's acting unpredictably, somebody's going to get crushed or whatever else, or you got a hole in your protective equipment that they know about and say, get on in there in those caustic chemicals anyway. Isn't that a lot different than just because of the nature of human behavior, where it's not as predictable, it's not as consistent, it's not as physics-based, I think was the terminology kind of used by the other side. Doesn't that kind of water down that knowledge of a probable assault?
no, I don't think so, because it's just whether or not the individual is dangerous and that something's going to happen. So, I mean, for instance, the state can have claims against them for negligent supervision of an inmate, and they base that on, it still involves human behavior, but they base those negligence supervision claims on prior attacks. Did they know that that particular person was going to be around the person they attacked? I mean,
things here, right? We don't have a prior attack.
Well, I arguably, I think that we do. I mean, his records made pretty clear that he had acted violently on several occasions. So the issue is this behavior from this individual dangerous in the sense that it could literally be anything at any time? And we think that the evidence bears out in the records that that's the case. So going back to the issue of Ms. Price's testimony, and she said, hey, this happens in public places. Well, her testimony was that it happened in public places, and she said courthouses, libraries, schools, that sort of thing, but it happens in an office. Her testimony was that, yeah, we'll rent an office or something. So the point is it's not that it's, the fact that it's in a public place doesn't negate the fact that she knew that her staff, particularly Ms. Jacobs, would be working with him alone. So, if there's a room right over there and the door is closed and this individual is in there with her alone, the fact that we're all in here really isn't going to protect her. So meeting in a public place doesn't really make much of a difference when you know that your staff is going to meet with them alone in a closed environment. And referring to Miss Jacobs' case notes and what she knew. It's appendix, let's see, page 3, and it's basically 700 through 704. But there's several instances where they downplayed the extent of his ongoing behavior. He's doing better, he's behaving better. He said, I know how to handle myself. Ms. Jacobs didn't know about the details in his records and that these things were ongoing. His mother and himself downplayed that stuff when they met with her. And Ms. Price's testimony, I'm sorry, if I can finish my thought, was that, yeah, I'm looking at the diagnosis codes, but beyond that, if you look at her case note entry, she did much more than just look at those diagnostic codes. She took specific sentences from the narrative, put it in that case note, so she knew that stuff, and she knew that he had ongoing issues. The last thing that was in those records with his mother's main concern was his ongoing hypersexual thoughts, and that was 2 months before Miss Jacobs met with him initially. She knew that stuff was still going on, and she didn't say anything.
Stout. Thank you, Mr. Gerlitz. The case of Jacobs versus State is now submitted, and we are ready for arguments in State versus Ford.
May it please the court? My name is John Moeller. I'm representing Mr. Ford. The underlying case is a claim of child sexual abuse against a stepdaughter. The interesting issue on appeal in this case is Mr. Ford was tried by a jury of 11 women and 1 man. I've done perhaps 200 jury trials, and I've never encountered a situation like that. It was just about like the JEB Alabama case, where there are 0 males in a case involving paternity. And in that case, the state did it.
Noteworthy, Mr. Mueller, about the gender makeup of the jury, then why didn't you raise your JEB challenge before the jurors were dismissed? The other jurors were dismissed, the prospective jurors were dismissed.
This is where I think the record is pretty unclear, because if you look at those transcripts, and I put them in the appendix, somehow, I've never done this again, agreed not to have the jury selection reported.
What's the usual remedy if you lodge a successful Batson, or in this case, JEB challenge?
In the normal case, Your Honor, you're dealing with one individual. That individual stands out as a member of a protected classification, and either you make that objection at that point or you've passed. I have no quarrel with that. But when we're dealing with gender-based,
Make a Batson or JEB challenge and it's successful, that challenge is given no effect, and that juror sits back down and is still in the selected group, right? So how do we, when that's the remedy, right? That's the normal remedy. What do we do after, the horses are already out of the barn by the time you're making your objection here, right? They've been sent home. Presumably they've been relieved of their admonition. They probably don't even have any obligation to answer a phone call if you called them and tried to get them back in. They could be researching this thing on Google if they wanted to, because they're not under the admonition anymore, because they've been told they can go, right? I mean, how do we put the toothpaste back in the tube at that point? To keep mixing metaphors here, sorry, but it's the timing of this really bothers me. If you're
makes that argument, Your Honor, and if the judge had indicated that I can't help you because the venery is dismissed, I can't help you by declaring a mistrial, then I would be in trouble. But the court went through the analysis, so even if...
By declaring a mistrial, But what the state's saying is, no, you can't put the court in that position by making that the only remedy now available because you've let the people go that we needed to keep here if your JEB challenges are granted.
You to look at a situation that did not occur because the court found that even if we were on the record and I said at 4:30, Judge, don't let this veneree go home tonight because we're going to be back in the morning at 8:30 and we've got some serious discussions to do. Now, in retrospect, I probably should have insisted on a court reporter doing that sort of thing because this was a shocking situation. We've got 28 people sitting out in the courtroom spacing under the COVID conditions. And we go through these strikes, and Miss Kelly Raines Cunningham's strikes, the pattern is in the motion and in the arguments. And the pattern of strikes is like 3 men are last. And when these jurors' names were called and they stood up and people started to say, you can leave, the jurors looked around and are shocked. There's 1 man and 11 women. The sense in the courtroom is like, what just happened? But it's 4:30.
Why didn't you call out at that point and say, hey, well, hold on a minute, let's stop? Well, first of all, I'm assuming, and I don't want to start talking about stuff that's not in the record, but I'm assuming this case went down like every case I've ever seen, which is when you're exercising strikes, the sheet's getting passed back and forth between counsel table, right? So you know who the state's striking. You know they're striking men off the jury, right?
Which has to happen if theoretically 50-50 male-female mix.
Is the pattern that you're complaining about, which is he's striking all these men off, or the prosecutor's striking all these men off the jury, off the panel, or whatever we call that group, you can see that developing, right? Because every time they bring the sheet back to your table, it's like, there goes another guy, there goes another guy. You know, that pattern's apparent, right? And those people are still sitting in the box, so by the time you recognize the pattern, there's still an opportunity for you to basically say, let's put a stop to this, Judge. I've got a problem with what's going on here. And that didn't happen, at least on our record, right? Okay.
And counsel, I know you indicated that it was not reported, but the claim seems to be that there were more females than males, but it looks like the state struck 5 males, but is it true that you also struck 3 males from the panel? And it wasn't like you weren't striking any males from the panel.
And the state's trying to do a statistical thing at one point, trying to act like it's a 50-50 chance of strikes. No, it's not. Let's step back a minute. There's 28 people here. There are 19 females, 9 males, roughly 1/3 male, as opposed to what you might expect population. Now, the state's trying to say you can go through those males and it's a 50-50 chance, and they act like if both sides are striking 7, that those men could have been gone, it was a 20% probability, it's just fate. That's not. When you use 5 strikes directed at 1/3 of the jury panel, that is an exceptional situation.
3 of those strikes for males as well, correct? I mean, you struck 3 males from the panel.
Mine was in proportion.
If the state was really hell-bent on getting all the men off the jury, had an extra strike, they could have taken the last man off the jury, right? And you could have had a
man off. I think we need to look at this case.
I'm not sure what to make of that comment. I'll go ahead and answer that in a minute. But my point is, if the goal here was to get the men off the jury, the state had another strike to do that they didn't use to take that last man off. And if they had done that, instead of striking a woman, they would have had a 12-0, 12 women, 0 men jury, right? But the state didn't do that. Is that accurate?
Her concern was men.
From a factual matter, that is accurate?
Her concern was men that might identify with my client, men that had children and were divorced, men that had occupations and appearances and similarities as my client. I think if you look at this case like it was an employment discrimination case, no employer admits that they discriminate against any nationality, any religion, or any race. So every single employment discrimination case is based upon a statistical analysis. And if we look at this statistically, this could not happen. And on top of that, Ms. Raines admits this. Now,
Going back to that statistical analysis, I wonder if you could focus on that 20% probability and why that 20% probability isn't significant.
Your Honor, because we're starting out with 28 people, 1/3 of them male. Out of those males, all but one are stricken. 5 of those males are stricken by the state. The state used 5 of 7 peremptory challenges at those male jurors. So there's acting like in a normal world, with each side having 7 strikes, then theoretically half the jurors will be gone. Theoretically, statistically, each side should have stricken 2 males. And that's where I'm at on the case. The state is striking 5. That's more than double the expected. So if you're looking at an employer that has no blacks.
EB violation as well by striking more than your two men?
First, no one asked, but I did give the explanations as to why I struck the men that I did. One of those men was so blatant to say, well, who's on trial here? You can question the complaining witness and her mother? Your client's the one on trial. You can't do that. I have a problem with that. Now, that is certainly a race-neutral issue, and I'm perfectly happy, and if you look at this, I did explain that.
I mean, right?
Sorry, the Batson dominates.
Are your arguments hampered, and I believe you acknowledge this, that we have a lack of a record of what really occurred during that voir dire, based on the fact it was not reported?
I think that's a mischaracterization by the state. The record was fleshed out by professional statements of counsel and the judge. And if I'm telling this is what happened in the courtroom last night to a judge on the record, and Miss Kelly Raines Cunningham is sitting there and she doesn't say, no, that's not correct, and Judge Burt doesn't say, no, that's not correct, there is ample record to do this.
Time is up. You will have additional time on rebuttal. Thank you.
Thank you, Your Honor, and may it please the court, counsel. Good morning. It's a privilege to be here. So I want to start with this. I think that the issue of statistics is a little bit of a red herring. I think the counsel is making a good point that the background rate isn't exactly a coin flip in this situation because of the makeup of the panel to begin with. But the link is in there if the court wants to see what the odds really are. The point I'm trying to make is that it's not way off on the tail end. It's some reasonable probability that this would happen randomly. But the other thing is it's not random. It never is when it comes to exercises of peremptory challenges. They're decisions being made by a person. It's just not the degree where you would infer intentional discrimination on the basis of gender. These are strikes being exercised for particular reasons, and those reasons were articulated on the record. I just wanted to make the point that you're not going to find a case that supports the idea that this kind of gender breakdown in the exercise of 7 strikes is prima facie evidence of discrimination. It's not, it never is. The remedy would be to reseat the person who is the target of the improper challenge. That person has no obligation to answer the phone for an unknown number if it calls them to resummon them, no obligation to report. If they've been released from jury service, the court doesn't really have any levers to pull, can't really hold them in contempt for, I think the statute says you can't actually have them back for another term of service. If you hadn't released them, you could assign them to a new pool or a new panel. That's in Chapter 607A. But if you release them, you can't assign them to a new term of jury service within the same 3 months. And then the other thing is that, and you're right that they could be researching the case. They're no longer bound by the admonition, so they could have contaminated themselves. And we know that frequently people do after their jury service, they will research the case. Also, they could have recommitted to work or childcare obligations and make themselves unavailable in that way. Now, I'd also point out that the defense isn't even asking for that remedy below. The defense is jumping straight to mistrial. And I think that raises and implicates the other concern that we have about error preservation, which is the sandbagging concern. Now, I'm not saying, in fact, undivided duty of loyalty here. I think defense counsel ethically should pursue the route that is most likely to lead to favorable results for their client. It's just that if this is considered enough to preserve error, if this is not untimely and too late, then there's kind of an ethical obligation if you think the petit jury is shaping up to be unfavorable or less favorable than it could be. It's kind of an ethical obligation to do that sandbagging, to delay the objection until the only remedy that the court could grant is the one that's most favorable to the client, is re-rolling for a jury that we think is going to be better. And that's not the remedy that should be granted in Batson challenges. It's first of all, it's way more costly for judicial resources and judicial economy. And second, it's not aligned with the nature. It can't actually remedy the harm that occurs from a proper Batson challenge, which is the exclusion of a person from the jury process on an improper basis, and it grants a strategic windfall to the defendant. The other thing that the Second Circuit points out in Biaggi and I believe McCrory is that there's an understandable reluctance by trial court judges. You can see it in how this trial court judge reacts, is that we've already, the only remedy I could grant at this point is really a mistrial, and we'd have to start all over, and they're understandably more reluctant to grant that remedy, and defendants can gamble on that to try to win acquittal or partial acquittal, knowing that then later they can argue the merits of the Batson challenge in a more, sterilized environment where there's not a jury waiting to try the case. There aren't witnesses waiting. There isn't a trial court judge who's, faced with those judicial economy interests.
Paul, you cited an Eighth Circuit case which seemed to be seemed to have fairly similar facts. In your recollection, are there any published or unpublished cases from our courts that have a similar scenario where there's a delayed objection?
Your Honor, I'm not aware of any. That's why we requested retention, because we think this is an issue that the Iowa Supreme Court hasn't decided. Now, if there were authority on point, I'd say this court would be bound by it. Since there's not, I think this court has the opportunity to, apply the Gottschalk test, calibrate our error preservation requirements in a way that furthers interest in judicial economy, promotes fairness, both to both parties and to the district court and to prospective jurors, I guess, given the nature of this challenge, and to avoid creating improper strategic incentives, and also to ensure that appellate courts are provided with the most complete record for review of preserved challenges. Now, the record in this case, one of the problems, and I recognize that we can make some inferences from argument and statements of counsel that are not subsequently opposed or corrected, but we're at a point where we've got a batch of Batson challenges. The fact that now we know that counsel could raise an objection to each individual strike as it happened, because counsel did do that. And when that happened, there was a record made about the individual person, about their characteristics, about their responses. And if there's, if that person's questionnaire needs to be in the record, it can be made part of the record at that time. Then you look at the difference here with this batch of Batson challenges, 5 all at the same time, as they're waiting for trial to start. And this is the day after. Recollections are not quite as fresh for Vordaer the day before. And, in future cases, it might not just be a single day. It might be over the weekend, or there might be a longer break between when Vordaer completes and the veneer is excused or dismissed, and then just before the jury is impaneled, the petit jury is impaneled and sworn in, then the challenge is raised, and that can be even less fresh, leading to a worse, or it undermines the ability of the district court to make the kind of factual findings and credibility determinations that are at the heart of phase 3 of the Batson analysis. And it means that the time pressures inherent there and the unavailability of the now excused and dismissed panelist mean that the court doesn't have as much ability to make the kind of record that this court wants. So instead of an individual, here's all the characteristics that are relevant for panelist A that was struck, and then we go through it and decide, the court makes a determination on one strike. We have all 5 of them discussed as a group, and we don't get a lot about any of them. The only thing we get about the 2 that I think the merits of this focus on are that they are divorced fathers. We also don't have anything in the record. We know from counsel's statements that there are divorced women who are on the panel, but we don't know that there are divorced mothers. If that's a fact that's relevant, right? If this challenge had been raised earlier, maybe the record would have been more developed to include that. It is the appellant's duty to create and provide a record that affirmatively discloses the error being relied upon. This record doesn't do that. To the extent that
Records show us that the jurors had, the rest of the panel or the veneer had already been dismissed.
Yes, Your Honor.
The comment made during the sentencing hearing where Judge Burt says, well, I think you needed to make that before we released it. The jurors suggesting that they, in fact, had been released before he heard about this. Is that the only place in the record, or am I missing someplace?
comments, and what you said encompasses both of them kind of. At one point, he says, I think you need to raise that before the veneer is dismissed. At another point, the judge says, by that, at the end of the day, 4:30, we excuse the rest of the, and dismiss the rest of the veneer.
That's all said during the sentencing hearing.
There's also the, concerning the juror with the medical issue that is brought up at the beginning, just before this motion is made. And that person's excused and then not replaced. They just go to trial with one fewer alternate, suggesting that everyone knew that these were the people that they had. There was no remaining pool of people to replace this person with to provide another alternate.
So it was clear that they weren't exercising the strikes yet that morning, so the people were still there. Obviously, it had already been pared down to the 14 that were supposed to be trying the case already the next morning when the record starts again.
Right. And everybody else had been dismissed. And there's nothing to suggest that the trial court was incorrect in its recollection in the statements that it made later. And that's very much like Clark, where the way that the record established that the veneer had been dismissed prior to the Batson challenge being raised was the comments that the court made later about what had happened earlier, about when the veneer had been dismissed. So same kind of record that we had, that the Eighth Circuit had in Clark to establish the timing of the challenges.
A reported voir dire, but we also don't have a statement of proceedings under 6806 under this record, correct? So it's just statements of counsel later raising is what we have to review.
That's right, and I see my time's expired, if I could briefly. Thank you. Yeah, and that's an option that the appellant has to create a statement of proceedings under 6.806. I think that the lack of the record undermines the argument, the inference of discrimination by comparison argument that is being advanced on the merits, because we just don't know about the women who were divorced, whether they were also divorced mothers, or if they had other characteristics that would have made them different in quality and would have explained the state's reason to strike these divorced fathers instead. Thank you.
There is not a prosecutor anywhere in this country that cannot come up with some race-neutral, sex-neutral reason for striking somebody. And I don't care if we're talking about the Pope or the President or Tom Brady. I can always come up with a reason to like or not like somebody other than what team they work for, what party they're a member of, or what their faith is. And this is the joke of Batson, and I've sat here and worried that the only way to stop this is to get rid of peremptory challenges, because those are all disguised. Now, the state's complaining, what would be the difference if after every single mail I challenged and we went in back? What would Kelly Raines have said? She would have said the exact same thing that she did the next day. She never said, I could think of more if you gave me more time, or I could have said more the night before.
Counsel, you recognize our court can't get rid of preemptory challenges. You're not asking us to do anything like that.
I understand that, but the sense of severity or what's happening here, I mean, there's law review articles that it's like a joke. Excuses, excuses. I don't like your age. You're too young. You're too old. Kelly Raines is saying, I don't like the Hispanic male.
Difference, isn't there, counsel, between the timing issue from the standpoint that you didn't go every time they tried to strike a man, because quite frankly, you wouldn't know the first time the prosecutor strikes a man, probably doesn't hit your radar, right? No big deal, right?
So I did.
That's not an issue on appeal, so don't mention it. But until you see the pattern develop, you're not going to raise the challenge. I don't have any qualms with the idea that you didn't raise it upon the first strike of a male, but once the pattern becomes clear, or the pattern that you're claiming exists appears, that the prosecutor is striking only men, as soon as that becomes apparent, that became apparent to you before they let everybody go.
Well, let me clarify. When you're passing that
time, you had to recognize a pattern as it was happening.
that sheet back and forth with 28 names on it and strikes, and the attendant tells you, here's your last strike, male, female, and you're looking to go to your next one and you're talking to your client. It wasn't until people stood up and we went,
what? Well, but if that's true, counsel, can't the same thing be said of the prosecutor that they didn't realize that, oh, it turns out I was striking all men. I didn't realize that until everybody stood up and all of a sudden I got 11 women and 1 man. I mean, if your theory there is true, that cuts both ways, doesn't it?
the prosecutor would love to strike any man at random. If we were given a jury list that said nothing but male and female, having done these trials, you don't have a chance with a woman. The Me Too movement, the Pew Research, the sorts of things that have happened, a woman is much more protective of the children. A woman is much more likely in this era to believe a claim of rape. The men are different. And the research, the man might believe that another man did not do something. And when Kelly Cunningham got a heads up with her motions in limine that I have a mother here who's been held in contempt of court for violating visitation orders, that she has made false allegations of sexual abuse concerning another father's teenage son. Kelly totally freaked and thought, to win this case, I need to knock out every man. That is there on the record. And she says this repeatedly. Now, was her bias explicitly directed that I'm getting rid of a man because of a man per se, or because I'm getting rid of a man because there might be a custody dispute and he might be receptive to my client? It's the exact same thing when the prosecutor strikes a black juror when there's a trial of a black male, because that black juror might be more receptive to thinking we all look the same, nobody can tell the difference between us, might be more receptive to thinking the cop has threatened or done something to them. And her express statements, when she's making these statements to the judge, I'm getting rid of divorced males, and she did not ask whether they had custody.
Next day after everybody's been released, right? Yeah.
I got rid of divorced males because I assume they don't have custody of their kids. That is an inherent characteristic. You're going by the race. She's making racially based choices. She's telling the court. I'm looking at Judge Burke going, gosh, I've never had anybody admit a Batson valid challenge, and it just happened here. I'm stunned.
Again, you said race again.
JED, I'm sorry, Your Honor.
Make sure we hadn't changed gears there for a minute. All right. Thank you.
Thank you, Mr. Mueller. Thank you, Mr. Slovan. The case of State versus Ford is now submitted, and we will be in recess.
All rise.